Now we're ready. Excellent. Thank you for being here. This is the Board of County Commissioners work session on May 22nd, 2012. It's about 5 past 11. We're a little bit late to start this meeting. The first item on our agenda is medical marijuana licensing regulations. And our county attorney, John Ely, I think, it says the staff responsible. Are you going to make the presentation, John? Thank you.
All right. Commissioners, what is in front of you on this agenda item is a proposed regulatory scheme to allow the county to begin to issuing licenses for medical marijuana facilities. Not only the infusion of products facilities, grow sites, but also dispensaries as well. The regulation, to be quite blunt, is modeled off of Boulder County. It tries to incorporate as few wrinkles as possible to try to keep this streamlined and relatively easy to administer, not only for people coming in for licensing and filing applications, but also for the staff that'll be tasked with administrating and issuing licenses, and the review of that licensing procedure as well. There are some decision points that the BOCC should weigh in on, need to weigh in at some point, and they're highlighted in the agenda item summary on the first and second page. The purpose of today's meeting is to have an informal discussion about what the board would like to see in the proposed licensing regulations, any changes or any additions, and then direct me to incorporate those. The plan is to bring this back to the BOCC at a regular meeting, the first regular meeting in June, for our first reading, and then to conclude the process at the second regular meeting in June, and have the regulations adopted in the form that the board is comfortable with. To hit on the decision points that I've called out, at least initially, first is a decision about a local licensing authority. The state law allows us to make that designation rather than having each license application proceed to the BOCC. The way the regulation is set up right now, the local licensing authority will be John Peacock as county manager. The other issue, or another issue...
John, would it be okay with the board if we address these points as we go along, so we can just deal with and so this particular issue, which is the local licensing authority, board, what's your feeling on that? I'll give my feeling on it, since I don't see hands shooting up. John, don't we as the board approve liquor licenses?
Yes.
Yeah, and so given that equivalency, I think that we should take the same stance towards medical marijuana licensing as we do liquor licenses. It's both are, although it's considered to have medicinal properties, as does whiskey. I think that medical marijuana is an intoxicant, also recognized as an intoxicant. So I would suggest that we do that licensing. But let's see what the board has to say. George?
I would agree. I had that same on my paper as well. It just seems to make sense that this falls under the same sort of concept as we do with liquor licensing, and so I would think that it should be the board's obligation, responsibility to be the agency that licenses.
Jack?
Well, John, why did you recommend, I have an opinion, but I'd like to know why you recommended the manager versus the clerk or ComDev or, anyway.
John volunteered. In other jurisdictions, although, as Michael pointed out, the processing for liquor licenses proceeds through the BOCC, other jurisdictions have taken advantage of the provision in the state law regarding medical marijuana to appoint an authority or an officer to deal with it administratively. So we easily do it with the BOCC or a staff person.
Jack, do you want to continue?
Yeah, I'm good with either, actually, and I totally understand where you're coming from, but I'm not sure how this fits in the scheme of things, because this is it's a different thing than alcohol also, because of the difference between the federal law and state law, etc. So I haven't really landed, but I did have a question to Mark as to the county manager.
So do you want to ask, so you're asking the county manager, is that a question, Jack?
Well, I made my statement, and then I just saw John's hand up, so I'm up for any information I can get.
John?
I think to build on John's comments, I think part of the reason we're looking at a staff position as the licensing authority is the role that we're taking is really just ensuring that what is required of the state is met, as well as, is it an appropriate location under our land use. So it's more of a workflow and check versus a policy decision. I think actually you have more, you're involved in more determinations in liquor licensing as to whether it's met the state requirements. So,
But nonetheless, there are some. So the question I think that's raised by the public is going to come to us. In other words, why is there a medical marijuana facility of some sort in my neighborhood? They're not going to go to the county manager. They're going to come to the commissioners anyway. So we might as well be informed to what we've approved and why we've approved it. I mean, that's my feeling. Yes, Rob?
Yeah, I'd like to raise the question of difference in liability of a local licensing authority versus the county in terms of, are we putting, does the local licensing authority have a heightened risk of liability given the fact that they're approving something that goes against a federal law?
No, that status is there regardless. So whether you nominate an administrative element of the organization, a staff person, to be the authority, or name yourselves to be the authority, the legal parameters of the action don't change.
And what are the legal parameters of that action in your mind?
You are complying with state statutory law to facilitate the issuance of a state and also by extension a local license for a medical marijuana facility, one of the three types of medical marijuana facility. It is contrary to federal law, and so there is some risk, but as I've said before, I think that risk is minimal. In fact, I had myself as the authority originally, and John thought it would be easier to handle through his office. So I don't think that's a distinction. And well, no second.
Rachel?
Yeah, I guess a little bit similar to Jack. I could go either way on the discussion, but I also feel a little bit that having a staff or administrator at some level doing this may take some of the politicalization out of this. I believe it's the board's role to create the policy of where are the appropriate places. But if it's really just going through a checklist to say, does it match the policy that we've created, and then it's either a yes or a no, I don't know that we would be able to go backwards, start searching for new things, to modify the code, to take care of any, a complaint here or a complaint there, once the code is passed. I think it's up to us to get the policy right in the first place about the appropriate locations and guidelines, and then I would see it very much as administrative. But so I don't know that I want to politicize every decision every time a license comes through.
Let's see, George and then Jeff.
I guess my only question or concern is, and it comes up next in terms of license renewal public hearing, but I would suspect that if, that there may be some public interest and comments that would want to come before the BOCC in regards to where a grow site may be or where a dispensary may be. And so if it was just an administrative, at some point, we were going to have this conversation anyway with the public. And so that allows that to happen as a one-step process versus a two-step process.
Jack?
Yeah, let me clarify. And from our previous couple work sessions, I understand that we're doing nothing different than essentially working within the context of state law. I mean, right?
That's correct.
I mean, really, all we're doing, and I don't like rubber stamping, but check off. I guess I'll use John's word. We would be checking off. Now, what we're talking about here is initially all of the facilities of one of three types throughout the county. This is the initial licensing. Now, the question George has raised is renewal. For renewals, are they all public hearings, or this says may? How does that work, John, the may part of licensing renewal?
The second item for discussion is the aspect of public hearings on an application. If you look at application process as involving either an initial application for a facility or a renewal of that same previous issued application, you can divide the activity of the authority, the staff or BOCC, into those two aspects. The statute allows us to hold a public hearing on any type of license application, but does not require it. So, the way the draft regulation is presented is that a public hearing is not required for an initial application and is not required for a renewal application unless accompanying the renewal application there has been a complaint voiced as to the appropriateness of this location or this activity or anything essentially concerning the previous period of licensed operation. And obviously the board can change that draft approach if you'd like.
Okay, so where I've landed on this, the first item, county manager, I think it's appropriate. I really like Rachel's insight into possibilities or potentials, and this is not I think, an issue where we need to have a huge amount of controversy. When this was passed in the state, Pitkin County overwhelmingly, and was it 70+%? Honestly, I
think it was higher, actually.
It's been too long. I don't think our social climate and our support for this item, meaning medical marijuana, has changed in any way, shape, or form. We're not less liberal. We're not more conservative. I don't think we need to create controversy unnecessarily, but I absolutely agree. And thank you, John, for the explanation about renewals. When there is a problem, you better believe that it does need to come before us. So initially, getting off the ground, as we said, and within the county manager's discretion of his authority as the local licensing authority, I'm comfortable with the manager dealing with those issues. But then when there are complaints and problems with sites or whatever, absolutely, I agree with coming before us.
Thank you, Jack. So, Rob, how did you fall on this issue?
I'm happy with the county manager.
And Rachel?
Yes.
Okay, so it'd be in the purview of the county manager. And then we'll move on to the renewal. Is that what we're...
Well, it's nominated as a renewal public hearing simply because that is the way it's drafted. But as I said, a public hearing is something that we can set up if the board desires for any type of application. The draft was constructed such that a public hearing is not required for initial application but only on a renewal application, and only if that renewal application is accompanied by some type of complaint, some type of allegation of a violation of the previous initially issued license, or some type of allegation that would constitute good cause for denial of that renewal request. If none of those are present, then the renewal application would proceed without a public hearing.
So do we agree with John's outlining of that? Rob?
Yeah, my first question is, how does this public hearing apply to liquor licenses in comparison? Do we require a public hearing for all liquor licenses? Is for either the first issuance or the renewal?
There is an opportunity for the public to address the licensing authority, which for liquor licenses, the BOCC. It's different in that public hearings for medical marijuana are particularly addressed within that statute with uniqueness. And so there would be a notice requirement, a particular timeline, and so forth like that. With the, you also have to recognize the practical reality of the way the Pickens County Board of County Commissioners does business. Even if we are not in a technical public hearing context, I really can't remember any instance where when we are in a public meeting that the board hasn't entertained a comment if someone from the public is there and wants to make one. So to that extent, that there is the opportunity to address the board prior to the board taking an action.
At our discretion.
Yeah, at your discretion.
At our discretion.
Exactly.
It's not,
Right.
Although it's a public meeting, it's not a public hearing in the sense that it's at our discretion of whether or not we want to take comments on it. But in this case, with the licensing authority being the county manager, it's no longer a public meeting.
That's right.
At that point. So therefore, it's even less of a discretion to have public comment.
That's right.
On a license issuance or a license renewal.
That's correct.
Any further questions? So what's the feeling of the board? To accept this hearing provision? Yes, Rob.
One thought would be that perhaps there would be things that would automatically trigger, or an appeal of someone might trigger a public hearing. I mean, if there's a complaint, a formal process where somebody desires to have a public hearing, much like in a land use action, if there is a neighbor or affected individual, they could appeal the land use action for, a public hearing of some sort. I could just see an instance where a license gets renewed and then a citizen doesn't feel that their complaint was addressed in that renewal of the license, and therefore can we have a circumstance where that triggers a public hearing where it's no longer at our discretion of whether or not we get that public comment, but we are therefore then forced to have that public comment in some sort of process.
Yes.
That would be my preference.
But isn't that what's outlined here, John?
I'm not sure, Rob, if it satisfies you, if you want something more. It sounds like what Rob is talking about more as an appeal.
An appeal process that forces a public hearing, because this is a public hearing at our discretion, is the way I read this.
No, this is a public hearing if there has been any complaint or any issue concerning the operation of a previously issued license, and that complaint could be anything concerning the ongoing operation, or if there has been any kind of history of violation of the previous license, or if any activity would constitute good cause for denial. And good cause is specifically defined within state statute as being a violation of any law of any state or local law concerning the terms and conditions of licenses, that there was any violation of local ordinances or regulations, or that there has been an operation that adversely impacted public health, welfare, or safety. So that would be the fine point that would trigger a public hearing.
So I guess I'm confused as what Jack said about the word "may hold a public hearing." It sounds like it's at our discretion.
That it is, it's in your discretion until you fix it in the regulation. The regulation is to define when you want to. You can do whatever you want according to the state statute. You can hold it all the time, or none at all, or anywhere in between. And so that, with what I just outlined, is what was selected for this draft, and certainly can be changed to make the board more comfortable with however you want to create a public process out of the application process.
I understand.
You do?
Yeah.
Rachel?
Well, I was just going to say, I think the confusion, at least even from my reading, was the first sentence is about what the state allows,
Yeah.
and then the second sentence is what our draft is calling for.
Got it.
So it takes care of it.
So we're in agreement.
We're in agreement.
The next item is fees.
Wait, I had one more question
One
regarding
more?
that as well. There was a circumstance with the city of Aspen and the denial of a liquor license, and the city of Aspen was subsequently sued based on the denial of the liquor license. So my question is, to what extent can we work a protection that the issuance of a license is to somewhat at our discretion, or at the sole, I don't know if the circumstance was the DeGraff property, and they just found that there was public complaint enough to deny a liquor license. I'm not going to weigh in on whether or not that was just cause to deny a liquor license, but I want to make sure that we don't have that circumstance from a legal point when our licensing authority feels that there's just cause because of complaints based on, the right to peaceful living, smells next door, or whatever. What justifies just cause to deny a liquor license, and how do we protect ourselves against a lawsuit where someone says, we had a complaint, but you can't deny us a liquor license because it's not at your discretion. We haven't broken any laws. So, you understand what I'm trying to get at?
I think so. I think, to be honest with you,
Let me, we're jumping back, actually, it seems to me, the first item in our agenda, which we have settled on. And so do you want to readdress that now? Is that what you're
No,
trying to do?
this is addressing public hearings and the rights
Renewal.
and renewals of licenses. I mean, obviously, if there's a complaint, they've already gotten a license because they're already operating.
The complaints are outlined in this memo. So what you're talking about is a complaint that's different from the complaints outlined in this memo. And I think the one was based on character of the applicant, and we don't have that in this memo. So do you want to add that?
So I guess I'm adding the topic of reasons for denying the renewal or the original license,
Yes. Yeah, I'm trying to get it clear on this.
I understand under the license renewal public hearing, once and if implemented, formally, the licensing authority would have the ability to say, okay, we've got complaints here, to have a public hearing, then the discretion is always with us. We'll evaluate the facts, take public testimony, and that this public hearing is a BOCC item, right, John?
Right.
So, Rob, what I heard you saying, that you want to make sure that we always have the ability, the discretion to deny. Well, that would occur relative to the facts of the case before us. So I'm inferring that this addresses what you're getting at, unless I've missed something, and that's, I guess, what we're trying to understand here. This does articulate licensing authority, says there's a problem here, there's been a complaint or whatever, and therefore we have good reason to have this public hearing through good cause. Then the decision is ours.
Jack, but I think what we have to do, is we have to conform to Title 12, Article 43.3 of the CRS. So that's not total discretion.
Well, then I need John to answer that, if
Yeah.
you don't mind.
Yeah.
All right. So, Rob, I think your issue could be addressed by incorporating additional reasons for the denial. By therefore liberalizing our discretion. I would say that I would recommend that I wouldn't go that way, I guess. I would advise against that, just because sometimes when you broaden the discretion and don't put any sideboards or any definition to that discretion, the discretion can be seen as being arbitrary and too loosely defined. So the discretion is bounded by the terms of the Medical Marijuana Act, and the three criteria that are in that act, which are restated here in the memo, are actually pretty broad. If there is a complaint regarding a violation of law, then the BOCC would make a finding of, yes, there is a violation based on this complaint, or no, there isn't. The other factor is there a violation of the license itself, any conditions or any terms? And then the BOCC would hear that complaint and then make a decision as to whether or not that happened. And then lastly, a very broad category as to whether or not the operation of the facility negatively affects the public health, welfare, or the safety of the immediate neighborhood. And that really is, in practical reality, a very broad category, but it does conform with state law, so it would not appear on its face to a reviewing court to be overly broad and therefore invite a determination that the action was arbitrary, without any defined criteria. So I think I understand your concern, and my advice would be to stay within the confines of the state law.
Does that satisfy you, Rob?
That satisfies me.
Okay, so we're agreed on that then. The next item is fees, and the board has the discretion to set fees at a level to defray costs. And John has recommended a $1,000 fee for application, and if a renewal involves a public hearing, a $2,000 fee to reflect public hearing costs. Do we have comments on that? Yes,
I
Jack.
have a question. It's been our policy throughout our organization that applications pay their own way. And I'm assuming now I'm certainly good on the 1,000 and 500. It sounds like these are consistent with other jurisdictions. The question is about the 2,000. Is that a little bit too stiff, or have we tried to, within our best ability, to understand what a public hearing would be, and is that number consistent, with staff time? And that's what we're talking about, staff time. So does the 2,000, that's consistent with other jurisdictions, but have we actually tried to digest what that means, and is it consistent with what a typical public hearing would cost?
John, you arrived at that figure, is that correct? Did you do the analysis that Jack's asking for?
Yes, Jack, and your comments are all correct. It is a reflection of what other jurisdictions are charging. It's also designed to defray the actual costs that the county would incur in administratively processing an application, and it's also not designed to realize a gain for the county.
It's not a profit.
It's not a profit center, exactly right. It is, however, somewhat of an estimation in that we have not been in the business yet. So we're trying to anticipate how much time it would take, and that's why, to be honest with you, I weighted it very heavily in looking at other jurisdictions, because other jurisdictions, particularly this one, Boulder, who has had experience in processing the application fees. If in practice the time is in excess of what we've allocated, then we'll have to raise the fees, and conversely, if the time is less than what we were anticipating, then we can reduce those fees. It's just difficult from the onset to predict something that hits it right on the head. So with that uncertainty, I've just looked at other jurisdictions. The 2,000, I would think, would be sufficient to cover a public hearing in front of the BOCC. The 500 reflects a lesser amount for the renewal because we've already had information on the property, and the 1,000 is almost universally imposed by other jurisdictions, so that's why I went with that.
I'm good. The rest of the board okay with this? Okay. We're on to insurance.
I'm sorry.
Yeah, that seems fairly complicated, but, so John?
These next few items don't really involve decision points for the board, but I highlighted them just for the board's awareness. Insurance, there is an issue of county's liability insurance policy covering or not covering the action that the county would take in issuing medical marijuana licenses. And that ambiguity arises out of the fact that this type of activity is proscribed by the federal government. However, our insurer is still reviewing the issue. They have not had any experience with any types of claims as of yet. They're conferring with other insurers of other counties and other local jurisdictions in the state, and so it's a bit of an unknown. I don't think that if the board is committed to going forward in the action, it should weigh too heavily on the board. It's just something that I feel is appropriate to make sure the board is aware of.
So, John, if the federal government said that the issuance of medical marijuana licenses was illegal in and of itself, what would we do?
Well, the federal government has in fact said that. And typically speaking, for general liability insurance policies, and certainly for the general liability insurance policies that the county has had since I've been here, this insurer as well as our previous insurance contracts with other insurers, there is always an exclusion for coverage if the activity which precipitated the claim is found to be illegal. And that's where you get into the realm of flying without a net, so to speak. However, because this is a new type of activity for our insurer and other insurers in the state, quite frankly, because there haven't been any claims that I'm aware of and none that our insurer is aware of in the state, the issue of an activity which is sanctioned by the state, yet prescribed by or prohibited by the federal government, has not yet fully been determined by our insurer or other insurers of local jurisdictions. It might be a problem for us in the future, however, it might not. The steps that were taken with this regulation is to incorporate notice language within the license itself so that people are aware that obtaining the license makes them compliant with local and state regulations but not federal regulations. There is also an indemnity provision within the application documents that are submitted to the county, which, although that indemnification might not actually provide funds for the county, should the county be confronted with a claim that is not insured, it at least eliminates a potential plaintiff against the county by recognizing that anybody seeking a license or anybody who owns property for which a licensed activity would be conducted on is essentially waiving their rights to sue the county. So I think we've taken it as far as we can, given the uncertainty with our insurance carrier.
You don't really fly without a net, do you, John? You walk a tightrope or something to that effect without a net. So, right? So we're walking that tightrope between federal government, state regulations, and in the case of the insurance companies, no net. We're providing our own net by asking for indemnification.
Sure.
George?
Yeah, and that was always the stumbling block, why we didn't do this a year ago, because of that risk, correct? But now you seem to feel maybe a little more comfortable in terms of the way this is going to be worded?
The risk has always been there, and the risk is still there. It's just a question of degree and comfortability with that risk. And And if you're comfortable with it and understand it, and accepting it and moving forward.
Board, Rob?
Just as a comparison again, with other licenses that we issue, whether it be a restaurant operation business license where, the safe handling of food or alcohol and the safe serving of alcohol, obviously we're not violating, or those operators aren't violating any federal law, so this is covered by our insurance policy. But theoretically, someone could, our inspector could be in violation of inspecting the restaurant properly, and then a death occurs, and then they sue the county for not inspecting properly or something like that. So there is a kind of a path we can go down to kind of see what liabilities might be there. Have you done any analysis of that to think of, if we're not covered with our insurance, this, again, as George said, this was the big problem when we looked at this 8 months ago. I'm a little worried about that. What risk of liability might we be open to?
Well, like I said before, I think the risk is not particularly great. The opportunity for complaint for failure to issue a license, I think, is remarkably limited. The opportunity for complaint for issuing a license that arguably should not have been issued, I think, is also limited in that this comports with state law and the activity comports with state law. The ancillary harm that might be experienced by either someone who is licensed to do an activity or someone who takes visits or transacts business with somebody who's licensed, I think those opportunities are also somewhat limited. I think that it's not a good analogy to draw perhaps to a business license or a food license, which the county does not issue, or a liquor license either. It is definitely its own animal. And like I said, there is that exposure simply because of the status of federal law. But I think the risk is less.
And along those lines, if I may, Michael, the one thing that we haven't compared it to yet today, I think we've had some analysis or some thought process with this, is a pharmacy, because we are talking about a medical practice of some sort. You're issuing marijuana for medical use, and we have pharmacies that issue medicine for medical use. And I know we don't issue licenses to pharmacies to operate in the county, but someone issues a license, and they certainly probably sign, waivers of liability and that sort of stuff, indemnifying whoever it is that they are getting those licenses issued from. And has there been any research done on terms of how that protection takes place? Because I could see a pharmacy issuing the wrong dosage or something like that and then being sued, and the person who issued the license being sued. I mean, I think that's a much better comparison than looking at like a liquor license.
Well, I don't have any familiarity with the operations of pharmacies in the county, I'll have to say that. I do know, however, that pharmacies are regulated by their own specific statutory treatment under a different title, much more akin to a professional license, for example, a license to practice law or practice medicine. So the regulation for pharmacists and the rules that pharmacists have to adhere to are actually quite extensive. That is a fairly well-regulated occupation. So again, this sort of stands out of the ordinary loop of what you'd expect. And I think the potential for possible liability, therefore, is also going to be outside of the realm of what you'd typically anticipate. Because there is no requirement to really force the county to issue licenses if we don't feel like it's appropriate. It almost goes back to your initial concept of additional discretion. If we don't issue a license, it's hard to envision a lawsuit against us to require us to do something that is specifically prohibited by federal law. So I think that the position that this is in and the unique status that this activity has under the law, being prohibited by one level of government and allowed by another, offers a limited window, a limited set of circumstances that we would be exposed for any kind of liability. I'm not sure how else to describe it, to be honest with you. I guess I'm just not seeing the risks. The risk is there. I have to just say that outright, as we discussed previously. But I don't think the risk is particularly high. I can't say it's not there, and I can't say we won't be sued. We can be sued for anything. But I don't think that I would be dissuaded just for that reason, for issuing or for adopting this license regulation and then issuing licenses. If you didn't feel that this activity was appropriate, I suppose I would really look for the justification in a different light. Not so much liability, but just because of what the activity is and what it represents or what it could be within a given neighborhood.
And another slightly different topic regarding the insurance issue. Are there any examples of businesses where the county has required the business holder, the business operator, to carry a certain amount of insurance and name the county or someone as a additional insured? For instance, if you were to do a special event in Aspen serving alcohol, you have to bond an insurance for that, and you have to name the city of Aspen as an additional insured, protecting that circumstance. Now, that's partially because it's on public property, but I'm just curious if there are any circumstances where the county or a government entity has required a level of insurance to be held by the operator to protect themselves and name the government entity as an additional insured. And I guess the question also lies whether or not they could get that insurance, given the fact that they've got this federal issue as well.
To my knowledge, we don't and have not. That's an interesting question, though. I didn't put anything like that in the draft. I thought it would just be, or potentially could be, prohibitively expensive for somebody who wants to, conduct business in this area, medical marijuana. So I didn't want to economically, prohibit them from the activity. But it is something that the board could consider, certainly. And I'm not sure what the cost of such insurance would be or how available it might be.
I guess what I'd like to find out about that is, I can't think of, I would never operate my restaurant business without general liability insurance and an umbrella policy, and my landlord requires that. Do these operations, are they operating without insurance? Are they ignoring the fact that an accident might happen in their store where someone trips and falls, totally unregarded to the marijuana? But there must be some sort of insurance element to these operating businesses, and are they protecting themselves against that liability? That would be the first place to get some information to see whether or not they are insurable.
Good question.
John, do you think you can pursue that question?
Sure.
Okay, thank you for bringing that subject up, Rob. Yes.
I'm thinking of what Bob has raised, I'm inferring from his earlier statements that what he's after is protecting the county's interest. The question I'd ask you, John, is does not the indemnifications contained within these forms accomplish that?
The indemnification, the purpose of the indemnification, to be honest with you, I was thinking more of additional layer of protection for the county for being exposed to a potential lawsuit, just eliminating a plaintiff, particularly. Because an indemnification generally doesn't actually provide you with much benefit, real indemnification, real provision of a benefit, unless there's an insurance policy to back it up. Because then all you're doing is relying on your ability to collect from an individual or a business directly. But like I said, I didn't think about putting that in there because I was thinking about the cost to the medical marijuana business. But it's interesting question.
So John will pursue that question. So, any further questions on, are we still on the insurance? I guess we are. So we're satisfied with the way it stands, except with the question of, can these businesses themselves be insured on a general basis?
And may I ask, when John researches that, obviously you find out about, or try to answer that question from the insurance company's perspective, and what other experiences other counties have had. Yeah.
So the next item is land use code zoning amendments. John, are there any that we need to do?
No, and there are none proposed.
Okay.
The precept being that the activity would have to comply with the underlying zoning that exists currently.
Okay, and that zoning is a business zoning, essentially?
There is the opportunity in the county to have home occupations of a limited type, so if it falls within that, if the proposed activity falls within those parameters, then it could be conducted that way.
Or business license?
Right.
Okay.
And then further restrictions, the only additional restrictions that are not, for example, found in the Boulder jurisdiction from which this was largely lifted, or state law particularly, we've got a 1,000-foot limit, although that is in state law, from a licensed child care facility or educational facility, and we also have a restriction from any, a preclusion from any licensed facility being in a multi-residential structure. Now, I'm not sure if there are any additional particular restrictions that the board wanted to incorporate within the licensing framework or not. You can talk about any number of things. I mean, literally any number of things. Areas of the county, particular zone districts of the county, wherever you simply just don't want to see medical marijuana facilities licensed, we can incorporate that within the body of this regulation.
George?
Yeah, this is really sort of the key issue for me and the point in terms of further restrictions. And we're talking not only dispensaries, but also grow sites as well, correct? And so given the current zoning for dispensaries, it's really only allowed in a handful of places, the Airport Business Center, down around Holland Hills, up in Meredith and Redstone. And I know from our...
I don't think it would be allowed in Redstone given the current zoning, but...
Redstone would not be allowed, okay. So, but I also know that it would be allowed. The DC zone district is the same as the B2. Right, would be allowed. And so I know from our discussions, not only up in Redstone, but also the Frying Pan, they were adamantly opposed to having any dispensaries in those areas. So I would want to see those restrictions put in. And I think there's probably similar concerns, although there's not a caucus area included around the Holland Hills where there already is currently a dispensary, but I think there are some concerns for any additional dispensaries there. The grow sites is also another issue. When I went around to many different caucus meetings with staff, with Lance, we heard similar concerns that certainly the rural areas in Picken County, whether it be the Crystal River Valley, up the Frying Pan, Enema, or the Snowmass Cap area, none of them supported any grow sites in those areas as well. So I would suggest that we would need to incorporate that in restrictions, at least to begin with, because that's the feedback we've gotten from our public.
So, George, are you asking the board to consider that? So exclusion from Redstone, exclusion from Holland Hills, and exclusion from Snowmass Capital Caucus area? Is that what you're...
Well, there's two different issues. One's a dispensary and one's a grow site. So dispensaries can only be located in business location, what's deemed. And there were 4. Holland Hills already has one. Dispensary, I believe, Airport Business Center has one. I know specifically that Redstone does not want one, nor does the Frying Pan up in Meredith. So that's a dispensary issue. And then you have a grow site issue. And again, going to all these caucuses meetings, the neighborhood caucuses all were not in favor of allowing grow sites within their neighborhoods. Now, that doesn't take into account the home operations, which they don't actually have to be licensed, is what I understand. So they
Caregivers, you mean?
caregivers, so they could still be within those areas, in the rural areas, with some of these other restrictions that you talked about. You can't be in a duplex and can't be close to a school. So there's two different issues, dispensaries and grow sites.
Okay. So, Jack?
Yeah, and let's take them separately. Dispensaries, I would assume our zoning takes care of that because that is a business operating within a certain district. And so our zoning takes care of that. I'm not sure how we supersede zoning through recommendations of a caucus or a specific unincorporated area, but, like Redstone, without having a public hearing process or something. Because caucuses, and undoubtedly yourself and Lance, went throughout the county, but they make recommendations. They don't set the policy, etc. Now that's what we're talking about. But I'd want a more formal process in these in the caucuses, whatever, and it might be consistent with what we said we'd do is go have some public meetings in different parts of the county. I just don't want to supersede something or set a policy against something that we haven't fully aired out. There's two sides of that discussion, and I was not present. I absolutely respect what I'm hearing, but I don't want to set policy because we've heard some things but not had a formal public hearing process.
What about if we ask staff to bring back some mapping of exactly where dispensary use would be in Pickens County and where grow sites would be, essentially 2 maps of Pickens County, and then have that discussion given staff's research on that. We're at almost 12 o'clock. We have a lunch scheduled. We're probably going to have a long afternoon, and I think that's the best way to handle it. George?
2 quick things. One, zoning really does not, the zoning allows certain businesses to locate. It doesn't necessarily restrict. And so what I was suggesting, or what I'm asking, is that we restrict in those areas. And I agree, I would support the idea of a public process in all these areas. I think it may be difficult to do that and still make the deadline in terms of the July 1st with all these caucuses and neighborhoods, but I'm happy to do that. I just think the timing may be an issue.
Can we not amend this and have that public process, and if it turns out exactly or one way or another, however, well, then we go ahead and amend this, because an amendment to this is a resolution process, right? You can easily make an amendment to a resolution. I don't want to jump the gun and put something. Then we have to have a public process, maybe to back away from it. So it's the horse and the cart issue. And they,
Well, how about the map and zoning issue?
that's a good place to start.
I think we should start there. I think we can continue it, I mean, we can continue this discussion at our next work session based on this particular information. Is there, because that seems to be a sticking point. So, is that the final issue, John? or-
Yes.
It is the final issue. So let's do, can we do that?
And the only thing I'd add to that for our consideration at a future discussion is John defines, as far as the restrictions of 1,000 feet from a property line, and I think we need to have a discussion whether it's property line or building line. I mean, who knows how big a property is?
John,
So we need
want to be
clarification.
consistent, I think, with state law and how they define distances.
Yeah, I would agree with whatever that is, and maybe you already have the answer, the property line.
Okay.
Oh, okay.
Rob?
I had one other note under the restriction, and again, it's kind of having a parallel with the liquor license, for whatever it's worth. When you get a state liquor license, you go through a federal background check, and you get fingerprinted by the sheriff's department here, and they do a federal background check on it. And every year with your renewal, you have to verify ownership of that business, and if you're above a certain percentage, I believe you have to have that federal background check. And I'd at least like to put it on the table whether or not that should be part of the licensing requirement and how to do that. We don't have to get into it now, but maybe some research on how that would be handled if we did that.
Yeah, I think the state requires ownership as well as employees to have that.
The state will do that?
The way the
see it in there is one of the
The
requirements.
way the state regulation works is it allows for a concurrent review by state and local officials. And so we have drafted that concurrent review into the regulations, and that's, to be honest with you, what allows this to be so streamlined is because we will defer to the state to do those types of background checks, the NCIC checks, the fingerprint check, all the things you just mentioned, Rob, and then we will accept the state's conclusion. And we can do it ourselves, though. I mean, it's possible to do it
I just wanted to make
ourselves.
sure it was being done on the state side, because I didn't see that information.
Yes, George.
One other concern is the issue on enforcement, and that ties in with some of Rob's concerns, but we know that the state has actually cut back in terms of funding for enforcement officers, and so does that then fall upon the county to pick up that chore and the expense of that? Because there could be substantial consequences to not only how dispensaries are actually being operated, but also as grow sites as well.
There could be. The cutbacks to this point seem to be most apparent in the speed and timing of the process of applications, to be honest with you. And then as an aside, to be honest, we just have not had that much interest expressed in the regulations. I've sent the drafts out to a few folks simply because they've contacted us or appeared in front of the board in the past, and that's been all the level of interest that's been expressed up to this point in time. It doesn't appear that this licensing regulation will incentivize a real growth spurt in the industry, so to speak. It seems that an equilibrium has been reached with the level of activity that's currently in the county and what you probably can expect in the future. So I don't know if that's a particular concern.
It's past 12, so...
Real quick, my understanding, George, and I thought about that, the reduction in staff, and this can always change, but the current reduction has not occurred on the western slope. A large number of those reductions have occurred on the eastern slope and in Denver, more populous areas. They still have the same number of enforcement officers on the western slope. Of course, again, that can change.
So staff has their direction, a couple of items that we want them to restrict, the insurance and mapping primarily, and we'll go forward from there. We'll meet back here at 1 o'clock. We have a meeting with John Bauer from the FAA.
Sounds good. Thank you.
Thank you, Mike.
Welcome. This is the Board of County Commissioners work session. It's May 22nd, 2012. It's 1 o'clock, and on our agenda we have an airport master plan update / discussion with the FAA, which is going to be exciting. Jim, are you going to introduce this subject for us?
I'd be pleased to do that if you'd like, Mr. Chair.
Thank you.
Over the past number of months and years, we've been working on a master plan at the airport to kind of look forward 20 years into the future and try to understand what kind of pressures and such are on the airport or might be anticipated, so that a smart planning process could be put together to reserve space, and ultimately then the community might have a choice about whether or not they want to respond to a particular need or not, but would at least give that forward-looking thought process. We've been very active in the community and talking about this project with citizens, and I think we've gotten some tremendous feedback. So today our hope is to spend a few minutes just kind of giving you a snapshot about where we are relative to the master plan. It's an evolutionary process, as you would expect a planning process to feel like, and share that with all of you. But our special guest today is John Bauer. He is the manager of the airport's district office in Denver. He has responsibilities for not only the state of Colorado, but Utah, Wyoming. Is there another state in there, John? All the airports, 140-some airports. We've had a great relationship with John over the years, and very pleased to welcome him back to meeting with Board of County Commissioners as well. John is an accomplished engineer and a fine manager as well. Joining John today includes Mark Miller. Mark is a project manager, or project engineer, with the FAA in John's office. He is our project manager for our airport. They assign different airports to different project managers. But the best part is that Mark is also the compliance officer for that particular office. And so when it comes to things we're going to talk about a little later regarding grant assurances and other points, both John and Mark are great resources for that.
Jim, can I just add to a little of what you said? I asked staff for a recap of how many public meetings we've had, how many meetings we've had, and I'll just go down. It's a fairly extensive list. We've had 11 charrettes with approximately 110 participants in those charrettes, and those charrettes were anywhere from 3 to 4 hours. So that's a minimum 330 hours of citizen involvement, perhaps 440 hours. 5 citizen input committee meetings, 2 open houses, 9 small group meetings, 14 airport tours, 8 BOCC work sessions. So that comes to a total of 49 meetings that we've had for this airport presentation. For this airport planning process, which is, Jim has not said this because he doesn't want to blow his own horn, but Jim has been responsible for coordinating those meetings and outreach to the public, and I just want to thank you, Jim, for doing that.
That's very kind. We know how valuable and important this community asset is to the citizens, and we really, as a team at the airport, view it as that it's the community's airport, and so they need to be invested in and understand its role and how we can best serve the community. So thank you for that. One of the things that I was also kind of thought might be helpful today was to talk a little bit about where we started with this master plan and bring us forward in just a short little synopsis. As the board knows, we started this back in 2007, started working on some of the background material, the nuts and bolts of the planning process. But then about a year and a half ago, in January of 2011, as Michael mentioned, we started with these planning charrettes, and I just nicknamed them brainstorming sessions. where we opened it to the community. We made some special effort to invite certain guests and participants, and we did things different than a lot of FAA-sponsored master plans are done for airports, but more common in our community, where we start with that community input first, and then we started to bring in the professionals and others that could help refine those ideas and bring us to a successful plan. Those charrettes were set up so that people had a few minutes where we kind of introduced them to Airport Planning 101, if you will. We didn't want to go too deep to try to slant the brainstorm process, but to kind of give them a little baseline to work from, and then to really dig into it. And they set up at these large tables with drawings of the airport on it, and we had people there who could try to capture those ideas and then start to draw them on paper, so that, and they'd ask the citizen and say, is this what you meant? And, they'd work it until they got it, what was in the eyes of the citizen. And we did that through 2 different sessions. We thought about who would come to them and made sure we had a broad spectrum of input from various thought processes, components of the community. And what I think is real key there is that everything that you see today came from the citizens, and our responsibility from staff and consultants were to make sure that we took those ideas and tried to understand them and work with them and bring them forward, while touching base with both the advisory committee that this board set up, as well as the public through open sessions and interested parties. So today, we've made a lot of evolution. If you look at some of those early concepts, whether they dealt with what the terminal looked like or what other parts of the airport look like, it's changed and continues to be tweaked as we get feedback. Today, the master plan is nearing the process where the alternatives have been narrowed down, and we're headed toward a concept that I think closely reflects that original thought process back in January of 2011. It shows a reservation of space, which in the end, the master plan really is kind of forward-thinking, and to try to avoid making mistakes by putting something in the wrong place that preclude choices for future generations to make about the airport and what they want the airport to feel and look like. So when we started to set aside a certain amount of space, naturally you have to start to look at some key indicators and think about how those influence what amount of space you want to set aside on an airport, in this case the airport. So when we looked at the terminal, for example, we looked at the forecast, which we used 1.67% annual growth rate in our commercial airline passenger traffic. And then we kind of projected out over 20 years, thinking about what that might look and feel like. Well, to make sure that you actually reserve enough space or vacant space on the airport, you have to pick some size to work from. So we used industry standards to come up with some ideas about how big the secured hold space might feel like, or baggage claim, and some of those things. In the end, when you sum up all those totals using industry average, since this is a planning process, not a design for a terminal, very big distinction there. We were just doing it for the planning process, not for a design concept. We used the figure 80,000 square feet, which is a number that the community has heard. And it was in a garden level with a second level on top of that. So part of it would be submerged. And then we continued to think about how to balance the access roads and those kind of things, because when you think about planning process, you need to make sure you set aside enough space to make sure the space could actually work. So that's really how we got to some of the kind of thought process that was used. The rest of the airport, there was concepts that included, whether or not a second fixed base operator would fit on the airport, how might that operate on the facility, and a number of alternatives were considered, and the one that's currently being polished or worked on as a second fixed base operator on the west side of the airport, along with a parallel taxiway to allow that activity. But it uses what's called the minimum operating standards for the airport to establish the amount of square footage that might be on that side of the airport. For example, our minimum standards, which have been in place for many, many, many years now, almost identical to what they were 20 years ago, identifies that if someone's going to come on the airport, you need to have a certain base amount of facilities to be able to give the kind of level of quality service that would be expected of the users and visitors to our airport. In this case, it means a relatively small maintenance hangar, a slightly larger but still pretty compact storage hangar, along with a facility that pilots and such can do their flight planning, meet and greet their customers, and those kind of things. Some of the earlier concepts had much larger components to hangar space and other things. Those have since been removed from the alternative that we're currently working from, and we're trying to be respectful and protect the environmental components. Owl Creek runs near there. Other steep slopes and other things are part of that process. So I think as the public kind of thinks about this process, it's important to remember that it's a space reservation component and that we're just trying to think about what kind of things might be coming to us over the next 20 years. It does not mean that any of these improvements will ultimately be built. It just means that we've thought them through as we understand them in this year or whenever the master plan might be adopted. So it's an ongoing process. If timelines work out, we'll have it ready for you sometime in August, but it'll take the amount of time it takes to kind of work through these issues and have a master plan that's comfortable for the largest group of people that we can find. So that's it in a nutshell. But I think if I were watching this program or suggesting, is that it really is just an opportunity to think about how the airport might look and feel if certain things happen, and if it's really not an end when we look at the master plan, it's a beginning. It gives, should some portion of this go forward, it means that it'd still go through all of the vetting process that you'd expect from any major project in our community, including whatever land use approvals are in place of the day of that consideration, and environmental components and air, water quality, all the good things that matter to our community and we value at the airport as well. So that's pretty much where I'm at, and we'll go to John when you're ready.
Okay. I guess the BOCC has a few questions. George?
Jim, a couple of questions. Thanks for everyone being here today. There has been, what I have perceived, some misinformation and some lack of information, but more importantly, misinformation that's been presented out to the community during different venues. And so perhaps you could just speak to some of the questions that I've had to respond to for the greater audience. One is, this plan, as you said, is a 20-year master plan. The airport did a master plan maybe 7-8 years ago or so. So why are we doing one so soon after the last master plan was approved? And then my second question is, the question has come up in terms of financing and who actually is paying for this. Are the taxpayers, would they be paying for any renovation, building of any new structure out at the airport?
Well, I'll take the last one first, since that one's pretty clear. The airport is a self-funding part of Pitkin County. We're an enterprise fund under state statute, which means we're not taking any local sales or property tax dollars. So any changes that are expected or thought about or could be occurring at the airport would not involve any local taxpayer dollars. The federal funds, there's also been a few questions about the federal funds that we receive at the airport in the form of grants. Those are not April 15th income tax type dollars. Many years ago, Congress made some wise decisions, And at that time, they set aviation up as a user-based entity. So if you buy fuel through general aviation, you buy an airline ticket or send mail or freight by air, you pay into the system through some taxes on those transactions. But those go into an aviation trust fund, not unlike the highway trust fund, which in turn comes back to communities through the FAA to make a strong national air transportation system. And so the users really pay for the facilities. If you don't use the facility, then you're not contributing to it. So that's the financial component of that. Regarding how we got to do another master plan so soon after we feel like we finished the other one is, and maybe John will end up speaking to this when he views it from the FAA's eyes and how master plans operate, but that airports and aviation is changing very, very rapidly. And we did our last master plan in 2004, and now here we are, 2012. So it's been 8 years. It's pretty common for airports to re-look at their facilities, especially if there's dynamics and some potential pressures on it, to do them more often than every 10 years. And the FAA historically has told us they'd like to do them between 6 and 10 years, thereabouts. So we're not jumping right back in. There is some unique pressures on the airport this time, though. We've had a great deal of interest about businesses that might have interest in doing their operation on the airport, and so in part it was to try to think through what that would feel and look like and vet it with the community before it became a real acute issue.
Okay, thank you. Rachel?
Yeah, just to kind of follow up on that briefly, and we didn't have our full packets of information we've been looking at over the past year or so, but did the previous master plan identify where a second FBO would go, or were there just more reserved areas that said future aeronautical use?
There was a little bit of both. It identified, the 2004 master plan spoke to the second FBO in some generalities. It spoke about the fact that historically there had been some lease terms established with our current fixed base operator, the folks who provide fueling and services and such to both general aviation and the airline industry. That could happen on the east side, but the site that's currently being talked about relative to a second FBO in this master plan is on the west side, and in the 04 master plan that was identified reserved for future aviation purposes, or aeronautical, one of those two.
So there was no hard and fast designation of a second FBO location?
No. It identified that both were potential sites.
Okay.
Board, should we move on to our guest? John, thank you for being here. The board appreciates it, and we feel privileged that you are here.
Thank you, Chairman. I appreciate the opportunity to come speak with you all today. This has been a very interesting process for us, and to answer one of the questions just a little bit further from an FAA's perspective on master plans, we don't have a specific hard and fast rule, but when we do see outside pressures and outside indicators that items are coming down the line that may be of concern to us, and I think what I'm alluding to, and I'll just say it, is the second FBO issue. We absolutely encourage communities to be proactive to address those concerns before they become a complaint. And I think that's one of the things that we were happiest to see the start of this particular master planning study, is we saw it as being very proactive. From an FAA standpoint, it's absolutely crucial that you get out ahead of that situation, and all too often we get involved after the die has been cast and there are very little solutions left on the table. So to kind of further Jim's position a little bit, we were very happy to see the community get out ahead of this one and take a proactive role in trying to resolve some of that from an outside pressure standpoint. Master plans in general, from the FAA's perspective, it's very interesting. We actually have guiding documents that help guide airports through our master planning process and say, very, very broad guidelines. And the reason they're so broad, and people often question us, why can't you give us some more specifics? Well, in our office alone in Colorado, Utah, Wyoming, we have 118 NIPIAS airports, over 140 airports overall. Each one...
I'm sorry, John. Could you repeat that? NIPIAS?
NIPIAS, National Plan of Integrated Airport System.
Oh, yeah.
And I forget, and we are absolutely famous in the FAA for our acronyms, and if I forget to spell something out, please, Chairman, catch me, and I will do my best to give you the full brunt of it. So 118 different, very unique airports. Aspen at times has demonstrated that they're somewhat more unique than others, and at times they're not. So it just depends on the day and the issues that we're dealing with. So our guidelines and our master plans are very broad. There are two very specific things that the FAA addresses during a master plan, and that is the forecast for the airport, what type of activity they're going to have. We actually approve that document. And the second is the airport layout plan and how that space has been allocated or reserved for that 20-year planning horizon. We actually approve that out of our office as well. What you'll see is the FAA, quite honestly, just speaking very candidly, approves very few things. We concur in a lot of things, basically putting the onus back on the airport sponsor or community that is working on those documents, but those are two things we are very concerned with. We've also shifted in, I would say over the last 18 months to 24 months, our philosophy in master planning, and I was happy to have Mark join me here today for the compliance piece, is we're actually looking at how planning impacts compliance. How does planning impact the compliance with your grant assurances? So every time, and I'll talk about grant assurances in a little bit, but every time you sign a grant, you're accepting 39 contractual obligations with the federal government. And we're actually looking at the planning process to ensure that we're not approving something in an airport layout plan that would be contradictory to those 39 assurances. And that's another reason we were very happy to see Aspen get out ahead of this, and the community is, it helps us understand that they have a knowledge of what we're looking for in a master plan, and they really are trying to resolve some of the potential compliance issues down the road through their planning process. So again, another reason to execute a master plan. We really use the master plan as a guide, as a tool in developing, not only the airport develops a capital improvement plan, and then the FAA we develop our own, and we develop one more on a global basis. Obviously, the airport is more concerned about, what taxiways, runway extensions, what items do we need here locally. We take all of that data in from all the master plans that are done throughout our system, compile a needs list, and produce that for 118 different airports in a comprehensive plan. So it's critical for us to know what those outside pressures are day to day and have that updated. And so we use that as yet another tool in our toolbox to decide how we allocate funding to specific airports, where it needs to go, and where are the pressures coming throughout our 3 states. So just a little bit from FAA's perspective on master plans. And Mr. Chairman, I don't know how you want to handle it. Do you want to handle, I've got several sections to cover. Do you want me to go through each section and then you can ask questions, or what would be your pleasure on that?
I think we'll go with questions on each topic. So, and are there topics questions on the topic of master planning from the FAA perspective? George?
Just a quick question. You talked about, John, about how pleased you were that we're taking such a proactive approach based on some of the current demands. But hearing what the process has been to date, we're still not finished with the process with all the vignettes and charrettes and meetings. How do you view that in comparison to what you've seen other communities do with their master plan process?
It's tough to break it out. I mean, absolutely a large amount of community involvement at this point. I mean, from our perspective, and the summary that the chairman was good enough to provide us, that's a pretty exceptional amount of work done on a master planning study. At some of our smaller airports, we might see 1 or 2 community meetings to discuss what's in the plan, and just depending on what show is, all the way to the Denver International Airport or Salt Lake or one of our very large commercial hub airports, where we'll see hundreds of people at some of those meetings. So, but the volume is definitely extraordinary as far as community outreach goes from what the process that we've seen today.
Board, yes, Rob?
John, you had said that the two things that you kind of approve for our master plan is our forecast and our plan layout. And I just want to make really clear that those two things, how we react to those and what we actually build and what we actually do after the master plan is really up to us. For example, I was by chance in Santa Barbara, and their master plan process that they just went through regarding their forecast and their plan layout for their master plan said that their forecast, they should have a 95,000 square foot terminal. They ultimately ended up, on their own discretion, building a 62,000 square foot terminal. So regardless of what you say our projections are, we have the ultimate say of building what we'd like.
Absolutely. I mean, you're not going to find the FAA stepping in and saying, Aspen, you're required to build an 80,000 square foot terminal, if that's how I read the question. That's not something that the FAA participates in. What we're trying to do is establish a general framework and how you're going to arrange that and what impacts it could or don't have on safety standards that are at the airport.
Thank you.
Chad?
Yeah, again, thank you very much, everyone, for being here. My question is about actual master planning and taking in both the commercial aspect and the private sector. As far as master planning, I'm inferring that the board, although we have all these assurances and, for funding and we've agreed to all that, the Board of County Commissioners ultimately has the ability to phase, has the ability to determine location. Is that factual?
Yes, we would have some input if we felt something would push our comfort of safety, if we were encroaching on a zone that we didn't feel comfortable with. But that would all be covered in our initial approval. We would look at all that in the initial layout and say, you've reserved too much space in this particular area, it causes us concern. But ultimately, as that plan is phased, it absolutely lies with the county. It does not lie with the FAA.
And that includes, and without getting into a legal discussion, that includes our ability to phase in FBOs?
That probably is a little bit different conversation for us to have, sir, and I think we will get into that as we start to talk about assurances and start to talk about how we look at those outside pressures to a certain degree, and I'm not trying to dodge your question, I'm just trying to be as honest and leave some room for conversation when we talk about assurances, but you do have the ability to do that within reason. And some of those market conditions that we'll talk about under assurances might give you a little bit more guidance and might clarify it a little bit more.
Well, I'm way into the presentation, as it were.
Rachel?
Yeah, I just want to kind of follow up and either reiterate or clarify the point Rob was making. I have not visited Santa Barbara, so maybe it's a three-way conversation here, but you are saying that they approved a 90,000 square foot master plan, but then only approved a terminal that was 65. So their space reservation continues to move to be there for 95,000?
Correct. Their master plan, based on the studies, my understanding is, based on the studies that the FAA did regarding future growth and needs and based on, traffic, airlines coming in and out, private planes, GA and commercial, their master plan was looked at a 95,000 square foot terminal. That was the need for their growth, their 20-year projection. The community decided that what they wanted to build was a 62,000 square foot terminal. So they actually built less because that's what the community
wanted. And I can understand that. I guess and maybe it's a further clarification for Jim or John or others to follow up on, but was the adopted master plan still a reservation of that much space, or was it was the master plan itself pulled back to the 62,000 square foot new terminal they built.
And Rachel?
You don't have a microphone.
Sorry, thank you. The reservation of space, our understanding is at 95, it's still for a 95,000 square foot terminal or 95,000 square feet of terminal space. That still exists in the master plan.
Okay.
What gets built is a combination of a number of things. Whatever the market needs are actually showing at the time, your ability to finance, what the community is willing to accept. And so that would be a whole nother process that we would go through. All we're doing right now in this plan is really reserving dirt for these potential future needs. Then we'd go through another process to analyze, okay, what would a design look like? Where do our actual demands come out? And that would come back, of course, through the board and planning commission and that sort of thing.
Thank you.
Well, yeah, and I just for the record, I'd like to say it real bluntly. The idea that we have a space reserve that's 80,000 square feet does not mean we are building an 80,000 square foot building. I will say it bluntly and clearly. That process has not even started yet as to what type of building we are going to build. We will have more public input and more meetings and more all sorts of things before we make that determination. So the idea of getting criticism that we're building an 80,000 square foot building is, quite frankly, ridiculous, because it's just the master plan. It's not the design of the building, which hasn't even started. We haven't even started that process yet. So I just wanted to be blunt and clear on that.
Thank you, John.
Okay, I have one more question, Mike.
Okay.
Sorry about that, but thank you. And to the extent you want to weave this into your discussion of grant assurances, that's fine as well. But when there is a master plan, whether it's an airport master plan or sometimes a land use master plan for other type of facilities that gets passed by board, you'll then see people come forward with applications that do not necessarily comport with that, and they will be requesting an amendment to a master plan, or, you know, people may have looked at what we put together and said, well, we'd rather have a second FBO here, we'd rather have a third FBO here. What is the process on that? Is it, can a board just say, nope, sorry, you know, we've determined the new FBO is going to be somewhere, and until someone bids on that FBO, there's no FBO? Or how does all that play together?
So you're kind of dealing with several very complicated situations, and they're all rolled into one.
That's why we asked you here.
Yeah. I got that after the first So in regards to the second FBO, the FAA's position on second FBOs is we don't force people to have a second FBO, but if there is market interest, so if you are receiving proposals and you have developable space to accommodate that, and they meet your minimum standards, so the developable space meets your existing minimum standards, we would start to question if there was resistance from the community to entertain those, what process are they following? And if you really want to relate it back to as basic as I can put it for you, is what FAA is most concerned about is you are following whatever process you have in place. So what process does the community have in place to engage a second FBO if one were to submit an application? There are all sorts of other spin-offs to that question that absolutely further the complication of it of, well, we want to be smaller than the minimum standards, we want to be different than the minimum standards, we want to go here and you said there. There are no obligations, at least from an FAA perspective, as long as you're designating space available on the field for an FBO. You're providing that space and it's economically feasible to do it. We basically say you as an airport and a community have the right to designate that. That you don't have to allow for somebody else to come in and dictate where they want to build a business on your facility. So I don't know any plainer language. I'm trying to think of how to make it clear, because it is rather complicated and it does get a little bit convoluted. But to address the matter just directly as I know it, we wrote a letter back in 1998, which seems to be the subject of a lot of conversation at Aspen. And I actually was part of writing that letter, and it was signed out by then Nance Early, who was the Colorado section supervisor, talking about, like, I can't remember, Jim, can you help me? Is it Lot B, or how'd they designate the different lots on the east side?
Yeah, there was Lot A, Lot B on the east side of the airport that were incorporated into the lease that Atlantic now holds.
So Lot B, we find ourselves today in an evolving situation as far as FAA policy goes in regards to that particular subject. As we examine Lot B today, I know you are all well aware of some of the safety concerns that FAA has had over the past 36 to 48 months, which Jim and his staff have worked very hard on regarding surface incidents and runway incursions. It would be my belief that if today you proposed putting more activity on the east side, that our folks from our runway safety office, which I do not represent, just for the record, and our 139 certification office, which is part of my organization but run out of Renton, would have some concerns in regards to that. Only because we're now placing more people and operations in an area that we've already identified as being what we call in the industry a hotspot. We continue to have surface incidents where we have vehicles on the active taxiway that are not supposed to be, have not been cleared by the tower to be in that area. We've had several incursions into the actual runway safety area, whether it be by dogs or people or other animals. We have seen that. And we have voiced our concern, and just for the record, I've sat in on several of the RSATs that have gone on here, and our folks are adamant with Jim, and he's somewhat in between a rock and a hard place, for lack of a better term. But we are very much interested and very focused on reducing the number of surface incidents and runway incursions at Aspen and not encouraging a situation that could potentially make that worse. So I don't know if that answers your question in a roundabout way, but there are a lot of issues interplaying here.
You know, it answers it to some extent, and I know, again, you're going to get more into this with the grant assurances. And as you've alluded to, in some ways we live in an unusual community. I've seen circumstances where people have bought lots and torn down entire brand-new homes and condo complexes just to improve their views. So what happens in terms of this issue of a third FBO if people say, well, that's very good and well, you're doing a second FBO, but you know, I'm willing to take the financial gamble, I'm willing to bond for its completion. Who determines the market and market demand? Is there a need for a second or third FBO? Or plus a third FBO?
What we're really getting into is, I guess, if the board or the community chose to try and put forward a proposal that economics wouldn't present an opportunity for a second FBO to be successful, the community would put that forward to the FAA, and our legal counsel, along with our folks in compliance, would look at that proposal and see if it was viable. I've seen several of these proposals come through at much lower activity rate airports and be denied. And I can go back and search my memory bank. It's been a while, but
the proposal to deny.
To deny. So that's the first step. Is those type of actions would be submitted by the community, a request to deny. Mm-hmm. Now, in regards to a third FBO, right now our understanding is the consideration in the master plan is to open up the west side for a second FBO. I don't know if the community has designated a spot for a third FBO, nor do I know if there's applicable room that would allow that FBO to meet the current minimum standards of the airport. So it's kind of a tough situation to answer a question that I don't know if the community's fully vetted that option at this point.
Well, I think that what has been floated is that if there was a way to make room for a second FBO on the east side, that would permanently foreclose any proposal or opportunity to build a third FBO on the west side, that we should go for the second FBO on the east side so that the west side can remain unused?
So, an interesting question. One, I think I've already stated the safety concern we may have. Two, my understanding is there's provisions in it, the current FBO's lease, a land take-back provision to allow for a second FBO. Understand that is not required by the FAA. The FAA's position is if an existing FBO is using all of their lease space, the FAA is not going to dictate to an airport sponsor that they have to give up some of that space to accommodate a second FBO. I want to make sure that that's clear. That is not an FAA directive. In regards to if you built a second FBO on the east side, safety concerns aside, I would say you still have developable space that meets the minimum standards that's shown on the west side, and the community has considered that at this point. I don't think you would be successful at slamming the door on a third FBO, to use your phrase. I have a feeling that at that point, the FAA would look at it from a planning perspective and say, you've already entertained and shown that you have adequate space to meet the minimum standards located on the west side. What is the reason for denial? The only other reason for denial, and it's an and, is the economic competition. We've seen 3 FBOs operate at facilities with significantly less fuel flowage than you have here. So I think it would create some issues.
Thank you.
Rob?
I just want to clarify, John, some language that you used, because I think it's, I want to correct some language that you used. You had said that Pitkin County had shown a desire to open up the other side, the west side, for a second FBO. And in reality, regardless of desire, it is open for a additional FBO because it is, as you just stated, usable space. So regardless whether our master plan defines hangars, taxiways, this and that, it is still open it's open right now for a second FBO because it is usable space. So it's not something that we're doing, we're just kind of outlining possibilities.
I may agree and disagree with you at the same time. I hear exactly what you're saying, but with undertaking this process that you've undertaken, you've now identified it as a applicable, available space. Is that not correct? I mean, you've shown that there is an opportunity through the planning process to accommodate a second FBO or an FBO on the west side that meets your minimum standards.
Give him the microphone.
I apologize. Just for clarification, what you're talking about is that what we've identified is that we have space that would meet our minimum standards.
Correct.
We haven't, I don't think the board has adopted anything, no final decisions have been made, but we've identified that as space that would simply meet the minimum standards for that second FBO, or third, or what have you, depending on what happens on the east side in the final decision. And at that point, that's all I think that we've identified through this process. And that's really a matter of our minimum standards. And Rob, I think to your point then, your point is that if we have land that under our minimum standards that has been acquired with FAA grant dollars, does that really give us a basis for saying no? And John, what I'm hearing you say, just for clarity, is that, well, it's unlikely, since you've already identified that this land would be able to accommodate those facilities under your minimum standards. Does that help?
And if I may just follow up with that, I guess my question or statement is, could we have just left that area without doing any research as future aeronautical use? And hence, what I'm hearing is we did the legwork for a future FBO, letting them determining that it will fit there. And we could have just ignored that side and just said future aeronautical use, and then they would have had to do all the planning and legwork to determine that their minimum standards would have fit in that space.
So let's go back to my opening statements about the master plan and why we are so happy that you've undertaken the master plan is because you've actually got ahead of the problem. Because ultimately, the way the FAA views it is there capacity to handle a second FBO at Aspen? We'll know as soon as there's a request. So what you've done is taken the proactive steps to get ahead of that. So instead of having somebody dictate that, you do have space that's available to accommodate a full-service FBO, meeting your minimum standards, and it's here, and this is how we see it laid out, you've somewhat taken the proactive step at this point in identifying that and saying, yes, you can go here. So ultimately, to answer your question, you are correct, that ultimately the way the FAA views it is if there is a market demand and a second FBO were to come and put in an application, the airport would not have the defense available, even prior to undertaking this study, that you didn't have available space to develop it. So does that answer your question?
Yes, it does.
Chad?
Yeah, I would assume that we could not have undertaken a master plan process and it have integrity without identifying what the land is. We couldn't have avoided it. We couldn't have said, well, let another generation look at the west side, because we would have been called on it anyway. So I'm not sure. We're here now. That's what counts. But what's important to me is a statement you made earlier about a second or third FBO, for example, in our case, is about economic feasibility. And that is a critical issue. How can we have one FBO? It's logical, just use the word logical, that another applicant can apply and go through the process, and if it's consistent with the master plan and the board approve, okay, a second one. But a third one, who determines economic feasibility? Because I can see the second one. The third one gets to be real problematic. And then when you get into assurances, I really would like to understand phasing.
We're not predisposing our opinion on what an economic analysis would be on even a second FBO at Aspen, because we don't have the data. All we can go off of historically, what have we seen achieved at airports of similar size or similar use, similar flow, fuel flowage. So those are some of the things that we comment on. So at some point, if you were pressed with that, it would be the community's responsibility to get back with the FAA, provide a detailed analysis of why it wouldn't be economically feasible for an additional FBO, whether it be 1 + 1, 1 + 2, whatever that looks like, and show us, and then there would be some conversations, and our legal counsel would obviously be involved in that, and we would have some conversations about what we believe the economic feasibility of that is. So, and we would weigh in. Now, ultimately, does that say that the board has to have a third FBO? No. It just says FAA's opinion is Aspen may be able to handle that. And this is after studies. This is not, as of today, this is not based on any information we have submitted from the community at this point. So it's all hearsay until reports have been done and studies have been undertaken that we can analyze.
The community you indicated, is that either the public or the Board of County Commissioners?
It would be the board.
Or anyone?
We would look to the airport sponsor, who we have those grant assurances with.
Yeah, just a quick comment. It goes back to one of my first questions to Jim in terms of why the master plan now after just 7-8 years, and then your comments in terms of, John, in terms of you're glad that we're being proactive, but correct me if I'm wrong, but it seems like the reason why we're in this master plan process now is because there has been some inquiry, some requests to look at developing a second FBO, which we've had this conversation, and it doesn't make sense to just look at a second FBO on its own without looking at the entire airport structure. And so that's why we entertained and started down this long process and road of doing a complete airport master plan that would then identify certain areas and space reservations, not only for terminal expansion, parking opportunities, but also additional FBOs.
Yeah, it might be good to just kind of take us back about 2007 or so. We were starting to get inquiries of interest to be a second fixed space or another fixed space operator on the airport, and in discussions with the Board of County Commissioners that were sitting at that time, the consideration was that they really preferred that we do that proactive step to start to understand the issues, however difficult it was going to be for the community to talk those things out, but to be proactive and make sure that thoughtful planning and consideration could take place well ahead of having to make some kind of decision that might be thrust upon us. So that was the position, as I recall it, with the sitting board at the time, and we continue to have interest in operating another fixed space operator on the airport. So we're trying to move through this process as best we can so thoughtful consideration can take place.
Thank you. And I haven't had a chance to say it yet, but thank you all for traveling through today and giving us your time. As many meetings as we have had, there's always a broader community that may have not been paying attention or participating through those meetings directly. And as you get the alternatives on paper, you start hearing more and more input and ideas. And so I'm going to ask you a kind of a blunt question, but this that we're working on so far is clearly in draft form. Nothing has been adopted yet. Would our board have an ability to say, hey, we've heard growth concerns, character concerns, all these sort of issues from a large segment of our community, and to that end, we would like to zone the whole west side as open space and remove this designation of future aeronautical use. Is that something that is within our board's purview? And if that gets into your grant assurance questions,
This absolutely gets into the grant assurance
portion. Okay, well, you go right into that then, but answer that question.
So, to answer your question as bluntly as you answered it, no.
No.
No. There are certain restrictions. That land has been represented to the FAA in grant applications on Exhibit A property maps as dedicated airport property. So that land has been designated by the board as designated for the airport. In order to change that designation, you actually have to apply through a release process with the FAA, regardless of whether there were AIP dollars in that land or not. It gets more complicated if there were, and I believe there were. So it gets even more complicated. So if you were to propose that, we would come back and say, clearly, from an FAA perspective, this is needed for aeronautical use. Therefore, we would not grant the exclusion from the Exhibit A, and it needs to remain as part of the airport's inventory.
Thank you.
Board, are we ready to go on to some discussion of grant assurances? John, are you ready to do that?
Sure. We've taken all my good material, though, for grant assurances and the questions we had on the master plan. So grant assurances, what are they? We've talked about it a little bit. There's 39 grant assurances that come with each grant. There are some that are even more special than others. When you buy land with AIP money, the grant assurances that come with that live in perpetuity. They never go away. So instead of just a string attached to the contract, we envision it as one of the giant steel cables that holds up a bridge. So it's not just a small string, it's there forever. On a typical development, I mean, we can use the runway extension project, for example. As long as we're not buying land mixed in with that grant, those have a lifespan of 20 years. So every time you accept a grant, you're extending that out for a period of 20 years from the date of that acceptance of that grant. So in essence, we always look at it as any airport we've got land investment on. There are several of those grant assurances that live in perpetuity. For development, they're good for 20 years, but typically when we have a sponsor such as yourselves, you accept a grant, at least one grant a year, maybe even more. So, you keep extending that 20-year lifespan out. So what are the grant assurances that kind of we're faced with here today as we have these conversations? One of my favorites, and Mark will laugh when I bring it up, is preserving rights and powers. It's something that has become more and more an issue, and what that is we like to assure that the sponsor doesn't do anything contractually to give away any portion of their ability to oversee those contractual obligations or their ability to run the airport as an airport. We've seen some airports, and some of their names have been mentioned here today, that typically will try and give away that responsibility, and it results in some problems with us. So that seems to be one that's at play a lot recently. More focused in on the Aspen situation. And I wish we would have provided a copy, and I apologize to the board for not having it in your packet, is a copy of the 39 most current grant assurances. Grant assurances 22, 23, and 24 are very pertinent to our conversations here today. Economic non-discrimination is 22, and that really rolls into grant assurance 23, which is exclusive rights. So in a nutshell, in a very condensed nutshell, exclusive rights says you can't grant someone an exclusive right to, say, be an FBO on your airfield. So you can't grant them contractually the ability to be the sole provider on the airport if you have space available and if it's economically feasible to have more than one. So those are very, very pertinent, and that's an and, not an or, in between those, and that's very important also because that tends to get missed in the conversation as, well, we don't have space or we don't have this. No, it's and. You have to have both of those as a competing interest. So those are kind of the discussions I think it's important to talk about today, and I think we've covered quite a few of those in our initial conversations on the master plan. But in essence, that's where all of our conversations go when we receive what is initially would be an informal complaint. So let's hate to use the FBO example just because it's so fresh, but we'll use it for lack of another good example. So if you had somebody who was proposing a second FBO on the facility and they were denied and they felt that it was unjust, the reason for denial was unjust, they would then file an informal complaint with our office, and we would work locally. Mark would be our representative and work through those issues the best he can in an informal process, gathering all parties together, hearing all the sides, having conversations, and seeing if there's any common ground to move the thing forward. Barring a solution in that process, it then moves into a more formal administrative process under what we call our Part 16 process, which is a formalized complaint process where they can actually file with the FAA administratively and say, we are being discriminated against at these airports, and here are the grant assurances that are applicable. We feel that the current FBO has been granted an exclusive right. We feel that we've been economically discriminated against. This isn't consistent with the airport's fee and rental structure. And they tend to throw the kitchen sink at it. And they go on and say these are all the grant assurances they violated. So just to tell you, there are recourses that are associated with those grant assurances from an administrative side of the House of FAA. So there's not a civil penalty. FAA doesn't do civil penalties. The courts decide that. Unfortunately, what we do, if we were to agree with the person filing the complaint, and this is after, so there's about a year-long process that this goes back and forth between all the parties of, no, I didn't, yes, I did, no, you didn't, yes, I did. Everybody gets a chance to plead their case. Then our director will write a determination of our compliance and division and say, here's our finding. So just to use an extreme example, if we were to agree with that second FBO that they were being discriminated against, at that point we would make a determination that we were no longer able to provide federal funds to the sponsor. And depending on the severity, and I hate to bring these up because it's what we always refer to as our nuclear option, but there are things that the FAA can actually go outside of FAA's grants. So it can be no more federal grants to a sponsor based on a violation of a contract with one specific entity within the federal government. They do have that far-reaching power. It's very rarely used, but it has been used as a stick in the past to say, you need to get on board or we will pursue this. So that's kind of the grant assurance process. There is no civil penalty. People say, well, you say that, but then we don't get grants. But it's not like a fine. It's not like, well, we find that there were damages against the second FBO in this amount. We let a court decide that. So we typically don't deal with that. But that's somewhat of the grant assurance process, and I know it's a little convoluted, and it's very, very complicated, and you almost have to be a lawyer or an engineer who's really smart to handle our compliance side of the house. So I know I've just skimmed over it about 40,000 feet on the grant assurances. If you've got some specifics in regards to the where-tos and why-fors and commitments, and I'd be more than happy to address any of those, or Jim, even if you've got questions. I know it's just very hard to break those 39 down into a.
Jack has a question.
Yeah, it's something that touched base on before, but now we're in this portion, assurances. Rachel asked the general question about setting aside land, and that's pretty much a no. And I'm talking about relative to our airport, not the world, the state's airports or whatever. But is there a possibility, okay, we're doing a master planning process, we identify possible east side second, a third or second on the west side, but when you look at the amount of land and how the character of our community is, et cetera, is it possible to put a conservation easement on or non-development protocol, whatever, on a part of it? Is there any part of it that could qualify? Because we can understand, and I'll speak for myself, I should say, I can understand how the process might work and competition and all of that stuff, but at the end of the day, we work as partners with the FAA, but we do not work for the FAA. We work for the community, and there might be a segment of the west side that we'd like to preserve. And I'm not talking about percentages, we don't know any of that. But it's been raised in our conversations.
So I might look at it from a little bit different perspective, something that if we were asked outright, could you put a conservation easement, the answer would be no. But could you plan accordingly with community needs to, landscape doesn't seem to be the right phrase, but use that land commensurate with community desires in order to enhance it for aviation use and protect the surrounding community from the impacts of that aviation use. There would be some opportunity to discuss mitigation strategies at that point, but an outright conservation easement, that goes back to grant assurance number 5, reserving rights and powers. You've now removed your ability to govern that land directly, and there are consequences for that. So I would suggest that you would look at it from maybe a little bit different perspective of what are some mitigating circumstances in order to be able to develop the west side. What are some mitigation strategies from a local perspective to satisfy some of the community needs at the same time?
Well, and then consistent with that, part of that might be phasing, which you said you'd touch on, I think, when you talked about assurances. Would you address that? Sure.
So in the phasing aspect of this, again, I think what tends to happen, and this is not isolated to Aspen. This is a growing issue we seem to be facing within the FAA through master planning processes. That people get very confused of, well, if it's in the master plan, that it's set in stone. So if it's say an 80,000-foot terminal building, then it will be built to 80,000 feet tomorrow. It's a 20-year plan. There's a 20-year planning process, and we actually encourage sponsors to really do the analysis in the design phase after the planning of what is our needs. Because the last thing we want to see is an airport get upside down on a building and build 80,000 square feet when today that might require 65,000 square feet. Because then you're maintaining and operating 15,000 more feet than you really need to. So at that point, we really break away from the planning side and we look to the community to make those decisions. And how are those phased in? And in answering, Jack, your question previously on FBOs, the way that differs is it comes down to market demand. So if you were to get a request for a second FBO that met your minimum standards today, is the community ready to follow the process that they put in place? That's what FAA is concerned about. So there is a local process here put in place by the community that says if we receive a bona fide response, this is the process we'll follow. That's where FAA becomes more concerned with how it's phased in. And I hope that answers it without being too ambiguous.
No, I'm good. The other question I'd ask is about the penalties. I call it a penalty. Okay, so no more grants, because our community raised the red flag and said, hey, we've had it. So we are okay with no more grants. This is just speculation, honestly. It never happened. But how about payback? Okay, we have X number of dollars, millions. Or is there any scenario where a community who didn't comply would have to pay back dollars for previous grants?
Yes, that is a provision.
Reimburse, whatever.
That is a provision that is at the, I don't want to say disposal of FAA, but it is an option within that discussion to talk about payback of federal investment in the facility. Absolutely. Absolutely.
Master planning is good.
Yeah, again, going back to the whole concept of the master plan and reserving space, as we discussed, the opportunities to perhaps conserve some land on that west side, whether it be for riparian issues, water issues, wildlife. But as part of the master plan, we could still define a area that would meet minimum standards for a second FBO, but still allow some of the additional space to be set aside as part of the master plan process. I thought that's what I heard you say.
We would have issue, Commissioner, if we received a request that said we're going to put an easement, we're going to protect this area as open space. But what I was alluding to was, is there an opportunity to allow for some mitigation in that area to block a view plane for somebody so they're not seeing the side of a hangar that's offensive to them? Or there's some mitigation strategies that can be proposed locally that we might be able to consider rather than a hard set easement per se, or some type of conservation easement that would remove that from your ability, because conservation easements are directly in conflict with your grant assurances.
Thanks. And I don't know just if you know this off the top of your head, Jim or John, but first of all, I want to really thank the FAA for all of the funding, the grants that you have given to Pickens County Airport. We've been able to do some great projects, whether it's the runway extension or the current work on the runways. Do you have an idea in the last 10 years or so what that number is in terms of what this community has been able to garner from FAA grants?
Combined between the FAA and the state, you're going to challenge my memory a little bit, but it's around $64 million of grant funds that have come in the last 10 years, give or take a little bit. So the FAA has obviously seen some needs here at the airport. Their focus is on creating a strong national air transportation system, of which, the Aspen Pickens County Airport is part of that equation. So, whatever choices we get to consider in the future, the FAA will be a likely key partner in that process.
Rachel?
Yes, thank you. And again, thank you. This is very informative. I have two questions, roll them into one, but you mentioned number 22, number 23, economic non-discrimination and no exclusive rights. What was number 24?
24 is fee and rental structure of the airport.
Okay, fee and rental structure. Then the other question is, of the 39 grant assurances, perhaps you could give us a little bit of an overview or outline of the assurances related to general aviation overall. We certainly have heard cries over the years to say, well, we shouldn't have those big private jets, or we shouldn't have private jets at all, or we should somehow add additional taxes or requirements of the larger jets to private jets to offset their carbon emissions or things like that. Are those somehow treated in those grant assurances?
Yes. So what it's more based, we don't really divide it up per se, GA versus commercial. We look at it very holistically. I'm going to look to Mark. What's the access provision, the grant assurance? Do you remember offhand the number for providing access?
Operation and maintenance.
Operation and maintenance. So in essence, to sum up some of the bigger issues we have with airports, access is an issue. And basically, from FAA's perspective, there are federal tax dollars in one form or another, and Jim did a very good job describing where those come from through a ticket tax, through a real type user fee. Because there is a federal investment in the facility, that access should be open and available to the people who need to access that airport, whether it be GA or commercial. You've got a few things in place here, which I know we're going to touch on even further in the conversation regarding some wingspan, 95-foot wingspan issues. Also, I believe some curfew issues, which were what we call pre-ANCA, the Airport Noise and Capacity Act. That one I remembered to define. Really it comes down to access. So if the airport, just to throw out, if any airport comes to us and says, we're really thinking hard about limiting the access to this specific type of user, an immediate red flag goes up for the FAA, because we're saying, no, you've made commitments to us that you're going to provide access to X, Y, and Z. And that's why our conversation on the 95-foot wingspan, I think, will be somewhat important to have today, to give you FAA's perspective from a safety viewpoint of why that was allowed and why the FAA was a partner in that. And we're more than willing to have that conversation when the time is right. But in general, what we look at is if there's federal tax dollars invested in an airport, it is the expectation of the federal government that that airport remain open to all types, kinds, and classes of aircraft that can utilize it in a safe manner.
Following up on that, again, would then we be able to say equally applicable to commercial and general aviation, we would like to institute a local carbon offset tax or program, or is that only the purview of the FAA to put those sort of additional fees or taxes? Would that run into the open and available access issue?
Well, I think you're going to run into the potential of a head tax issue and how that exactly breaks down. I'm, again, not a lawyer, but we have had some proposals that fall along those lines, and there's some head tax issues with that. There also, there's a responsibility to prove that it's not overly burdensome. Is it reasonable? There are certain caveats. Some may view that as a issue to offset noise concerns, which is controlled by the Airport Noise and Capacity Act for Stage 2, Stage 3 aircraft. And I know I'm talking a little bit out of the Stage 2 and Stage 3 gets a little bit difficult to define in an open forum, but there are definitions to what that exactly means. But we have seen airports attempt to do similar things, but really, when you look behind the curtain, it is an attempt to restrict the airport and restrict access from aircraft that the community has deemed noisy. And that is a purview of the federal government under ANCA. So,
one component before we get too far off of Stage 2 aircraft, and those are really the airplanes that when you're out in the community, you probably pause and look at the airplane. That's kind of a generalization to say that's a very noteworthy airplane that just passed by you. Pitkin County was one of the first airports to join a coalition of airports who did get some legislation changed in the most recent FAA bill that will phase out those type airplanes by 2015. So there is a place in there. I just couldn't miss this opportunity to share that we continue to be proactive in regard to the noise issue. And Rachel, I understand yours was more toward greenhouse gases and such, but I just wanted to make that point clear to the community.
Thank you.
We're going to take a break. We've really put John on the spot here. He needs to take a break. I need to take a break. It's 2:15. We're going to continue till 3:30, so we'll just take a 10-minute break and let everybody stretch their legs and relax a little bit.
Good call, Mike.
Hi, welcome. This is Board of County Commissioners work session. It's May 22nd. It's about 2:30. We just took a break. We're in the midst of a discussion with John Bauer from the FAA, and at this point, we're still talking about grant assurances to some degree here. And we were in a sort of a question period. John, would you like to add anything?
If I may, kind of the summary to provide just a broad picture of why the FAA has the grant assurances in place. One, they're all derived from statutory guidance or policy that's been put forward either by Congress or the FAA, all of them. And all of them are an attempt to provide facilities that are operated in a safe, efficient manner that provides access to everybody who needs access. So that's kind of the nutshell of the grant assurances and why they're in place, and really what FAA looks at when they put those together. And they are always evolving. In fact, this year they changed slightly in several areas. Nothing that would be key to our conversation here today, but they are always evolving.
Are there any further questions from the board on grant assurances? So the next topic of conversation is fixed-base operations, which we've essentially covered, I think, in all the questions we had earlier, unless there are further questions from the board on that. John, do you feel it necessary to talk about fixed-base operations any further? Rachel?
Yeah, thank you. I'll try and keep it kind of succinct. But I think we've been using a term here, I'm trying to find it, of economic viability, that's one of the few areas that you would make a determination as opposed to just a confirmation or a concurring. How do you define economic viability? Is it the ability of the operator to potentially make 2% a year, 10% a year, break even? Is it have more to do with the competition and fuel prices so that the individual operators of their aircraft have more selection of opportunity of choices? What is economic viability?
So when I say we, I speak to the broader FAA. Okay. So typically it goes through what we call the airports division of FAA. That's the division I'm involved with. But that would go up to some of our economic analysis folks, both within our organization, maybe legal counsel, and one other group that tends to have a great deal of economic factors type issues, same group that would review a benefit cost analysis, say, that was submitted by the airport for a runway extension. So those groups would analyze that. But really, ultimately, if you want to break it down in very simple terms, from FAA's perspective, is if there is a market demand, if you are having requests for FBOs, then you're going to face somewhat of an uphill battle, because the market demand is how FAA will judge a lot of their perspective on economic viability. Because if there wasn't economic viability in a situation, typically we don't see demand. So that's kind of the FAA's initial viewpoint on it.
Just to kind of follow up, I'm kind of thinking a little bit of like the Bureau of Land Management process, where individuals can nominate any piece of BLM land for a potential leasehold, whether or not it's a high production value or moderate production value. And they also, at the same time, try to balance against anti-speculation, that someone's not just trying to lock up public lands with one drill rig for 10 years and another drill rig another 10 years, just trying to hold it until the market improves enough and there's enough demand. Do you have any sort of anti-speculation provisions so that, if there were someone willing to lose money on their FBO for 10 years, but they kind of have a lock on that location, how do you guard against that?
That, honestly, I don't know that we get into that depth on it. Our economic folks may, and I don't know the answer to that question. Okay. But what we do from our level, what we would look at is there would be certain provisions required in, say, first an RFQ and then maybe an RFP, and that would be the immediate use of that facility. So they would be given a defined timeline where if you're going to lease this land you need to show that you can utilize it and you need it all in your business plan for your operation. So in essence, it's a little bit a different way of addressing the speculation concern, because what has happened in the past is we've seen existing FBOs, not here, please understand, I'm not speaking about Aspen at this point, this is just generally throughout the country, is we'll see an existing FBO continue to gobble up land as it becomes available and then not do anything with it to preclude anybody from having an opportunity to operate on the airport. So again, I'm not speaking towards Aspen, but that is something that we have put in place to try and preclude some of that speculation and some of that kind of land banking if it's not going to be immediately used.
Okay, and to follow up, I think you just alluded to one of my other questions. When there is, whether you've done a new master plan or you're working off an old master plan, when there start to be inquiries and proposals to say, hey, I've got a great FBO plan here, at that point, if the commission was to entertain that, you do have to basically open it up to everyone and put out a request for proposals. You cannot sole source to say, hey, we got one proposal, sounds like it's just a perfect fit, that's what we're going to go with. We have to open it up to any and all comers in a reasonable standard and then judge them among themselves.
Yeah, and we would look at the process that was followed, and we would be commenting throughout that process, trying to help guide you to keep you out of any potential pitfalls of exclusivity or any of those issues.
Okay, thank you.
Michael.
Any further questions?
Michael?
Yes, Rob?
It's kind of a multi-parter or multi-element question, or maybe just talk about. In the elements of a new FBO coming in, for example, the way our draft plan now is for the west side development, additional hangar space, a completely new additional taxiway, there's a tremendous amount of cost and expense for whoever, whether it's us putting some of that money towards that, or whether it's the FBO putting some money towards that. I'm curious as to what guidelines the FAA restricts on those sorts of lease elements. You know, in the free market, if there's a plot of land and somebody wants to put a restaurant on that plot of land, well, part of the lease arrangement might be the landowner giving outfit money towards it, getting it back via lease, rent for that land, and how does the nuts and bolts regarding FAA's guidelines or FAA's control over how that happens? I mean, can we just tell an FBO, sure, if you want to build it, but it's going to be, you know, $50 million because you're going to have to build the taxiway, you're going to have to build, you know, all the hangar space, you're going to, and then on top of that, we're going to charge you, you know, $100,000 a month in rent or whatever. But as Rachel said, in our community, be well aware that there are people that would like a warm parking spot for their jet. So they might be willing to pay for that. So what guidelines does the FAA have on the dollars in and dollars out on a second FBO, or any FBO for that matter?
What you're really getting into is market driven. I mean, the majority of what you're talking about is going to be driven by the market. We don't necessarily weigh into that degree on request for proposal or qualification, because the market's going to drive that. I mean, if you put out a proposal that says it's going to cost you $500 million to build an FBO here, market will determine whether that's reasonable or not.
It would be a way to stop an FBO to say that they had to build all that stuff.
But when you get into that, what you've got to be aware of is then they can actually come back and where we would get involved is they would say this is unreasonable. This is an unreasonable demand, and they would, we won't, we're somewhat of an amazing organization. We won't tell you what we deem reasonable, but we will tell you unreasonable, unreasonable, unreasonable. Now this seems reasonable. We won't set that bar for you, but we will tell you what we deem is to be unreasonable. And I don't know any better way to say it. Commissioner, I apologize. I mean, it is what it is. We just don't say this is the adequate fee and this is a non-adequate fee. It's somewhat of a trial and error. But that's where we would get involved. If we felt that you were trying to preclude a second FBO through that manner, we would weigh in and say this is really not a reasonable attempt at this.
So let me just follow up with that. But it would be unreasonable for us to have to incur additional cost in getting a new FBO, in the sense that you would define the safety standards for a West Side FBO in terms of the aircraft entering the runway space. And I think our master plan has determined that there would be a need for a second taxiway on the west side, or at least a partial, which certainly is a tremendous expense that we could put on any new FBO operator that would be coming in saying, well, we're not going to build it, so if you want to put an FBO there, you've got to build it. That, to me, that doesn't seem unreasonable. Would the FAA see that as unreasonable?
You know, Commissioner, it all depends. There are other avenues that you would explore at that point, and that's one of the reasons you're undertaking a master plan, is to put together a capital improvement plan that would be viable for the life of your airport. So there are other funding mechanisms out there. It's a little bit more complex than just saying, you know, FBO, you'll build the second taxiway because we're not going to incur any expenditures. Well, what efforts, in a determination of reasonability, what efforts is the airport making to secure other funds? Have they put in an application through the airport improvement program to build a second taxiway? Have they and been denied or not received that money? You know, what other steps are in place? And I'm not saying you can't put it in a request for proposal, but I am saying if there is a reasonableness determination, you're going to have to provide clear, evident documentation as to your thinking of why that was a legitimate way to go.
So does this lead us into minimum standards? Is that
Michael, may I-
yes, Jack?
You know, I can understand what you just said, John, but for me, the issue of, okay, better way to describe it, what drives a second FBO here or more is competition, and, you know, why we can't prohibit. But I can't see the FAA telling us if we go ahead and master plan, space available, applicants go through the process and qualify for a second FBO, I can't see how the FAA could basically require us to participate in building the infrastructure under any conditions, because there's always matching money in FAA. And that means you are requiring us to use public dollars to support a private function. I don't think we do that. I think this FBO that's here is standalone. They built their own infrastructure, etc. Now, I can't go back 20 years or more to figure out what that fine line is of what existed. I honestly, I can't. But it just seems inherently wrong that there might be a possibility the FAA, through the processes and fairness, say, well, you might have to figure out a way to come up with a funding mechanism for additional taxiway. That's problematic for me.
Yes, John.
And I speak only for myself here, of course.
Yeah, Jack, I believe, though, that some of the infrastructure that's used by the current FBO, for example, the apron, was actually constructed with FAA grants. And so I think the discussion gets into equity and have we plan these spaces in good faith.
Well, that's a discussion we'll have, and that's why I said I can't go back 20, 30 years, and I don't know what existed technically.
So just from an FAA viewpoint, what we view the distinction between the support tax dollars going towards a private entity's operation in a situation, even under the current FBO, we would typically carve out a certain distance away from the hangar door because we would see that as dedicated to that individual. But in regards to the apron out in front of it, they're servicing the public. I mean, they're an entity on your airport servicing the public. There may be private aircraft, but those are the constituents of the United States, and that's what the airport was really built to handle. So we do carve out a certain, very small, and it's been a while, so please forgive me, but about 15, 20 feet away from the hangar door, we say, no, that's kind of your dedicated space to get airplanes in and out of your hangar. but the space outside of that can be used to park aircraft for your business, and there have been AIP funds obligated to that under those premises because it is for the traveling public, whether it be commercial or GA.
We're satisfied? So minimum standards, John, do you want to address those?
We like airports to have minimum standards, thank you. You know, we're hearing a lot of different comments, minimum standards. We had some conversations a bit ago about minimum versus maximum standards. The way we look at these is they're minimum standards. This is the minimum required. Where we see the most conflict, and this is not Aspen, again, particular, this is our experience through 118 airports and even more throughout the nation, is when you try and adapt those minimum standards to meet a current proposal. So if you were to go in and modify your current minimum standards to meet a proposal that was on the table, that is where we find the biggest conflicts arise for airports, and that's when we get involved, is when we receive, you know, some type of complaint process informally that, well, wait a minute, I'm the existing FBO, and they're modifying their minimum standards for an FBO to accommodate someone, and they're not having to meet the same investment that I did, and now I'm at jeopardy because of it. That is the single biggest complaint we receive about minimum standards, and it is typically focused around the FBO arena. So as far as we're concerned, you do have the opportunity to change those minimum standards from time to time. That is the prerogative of the community to change those. We typically like to be involved with any of those changes because we can give you some pretty down-to-earth feedback about what we've seen in changes to FBOs or minimum standards in general. Even hangar leases, access to hangars is a big issue, is another big one for us. But we would like to be involved in that conversation with you. All we do in that is lay out pitfalls. If you do this, we've seen the result is this. And we would give you that kind of 40,000-foot view of our experience of modifying minimum standards. But absolutely a very important document to have on hand to address circumstances so people understand what does it take to operate at my airport? What does it take to operate at the Aspen-Pitkin County Airport? So barring that, we do a lot of, is this minimum standard reasonable? We do go back and forth on that quite a bit with sponsors and say, you know, while we understand the need for this, it may not be reasonable to require a 500,000 square foot building when you only have 100,000 square foot of space available. So we have those conversations on a pretty regular basis with folks. But I mean, other than that, those are kind of the high points of minimum standards.
So board, are there questions about minimum standards? Yes, Rachel?
Yeah, now if, again, just kind of a hypothetical, but if we maintain the same minimum standards, and whether it's east side or west side, and there's a new master plan adopted, someone comes in and proposes to build more than the minimum standards, or more hangar space and more terminal facilities, we would have the ability to say, no, we don't want any more than the minimum?
Really a fine point question for us. So the airport board has the ability to control growth on their airport to the extent that they're not precluding somebody from operating there. So we at FAA don't look at them as a minimum maximum, and that's kind of maybe what I'm hearing is this is a minimum standard, but it's also a maximum. If that were to be proposed, we would want to see some clear justification of why. What are the parameters that are controlling that? Are you reserving the space immediately adjacent to it for T-hangars? Are you reserving the space next to it for a different kind of use? What is the thought process behind the community's response to a minimum maximum approach to something?
But I guess my best analogy would be land use, although I know there's no apples to apples here per se. An area gets master planned, it says it's going to have 12,000 square feet of commercial and 40 homes. And a developer comes in and says, well, I've purchased it, but I'd like 18,000 square feet of commercial and 60 homes, and we think that'll better serve your community needs. The board may say, well, that's well and good, but we've decided this is more appropriate for this community, for this location, to stick with exactly what we have in our master plan, therefore, we're rejecting your proposal. Is that clarifying what I'm trying to get at a little bit more?
Yeah, and I think the board has a certain latitude, obviously, to control the way your airport is developed, but all the FAA asks is if you're going to do something like that, that you have a clear, justifiable reason for doing so.
Thank you.
And that it be documented.
Any further questions? Yes, Jack?
Okay, clear and justifiable reason. We don't want 200,000 square feet of hangars on the west side. We believe it's out of character, inefficient, can't use safety reasons, because you all certainly are very pointed about safety, and we'd work cooperatively with all that. But we don't want 200,000. So if someone comes in and said, this is my plan, and I can't economically make this plan work, this second FBO without, what discretion do we have? I mean, what I'm inferring, somebody could blow our airport up to some balloon operation that we don't want.
So again, you have the control to develop your airport the way you want to develop it, as long as you're not precluding somebody for an unjust reason. So again, you know, that statement is a broad statement. We want to see what are the nuts and bolts behind that statement. What is the reason? Is it a community issue? Is it acceptance of the airport? Is there environmental concern? What is the issue that's driving that desire, Commissioner? What is the, and that's what we'd be asking for in that justification. You know, just to blanketly state we want to limit it because we want to limit it because it's out of character. We would say, okay, we pry a little deeper. Why is it out of character? What is the character of Aspen? Please provide us the justification of why you've taken this stance. And then we would have some back and forth and some conversation in regards to that.
Further questions on minimum standards? Okay.
How about wingspan?
Well,
No, I mean, excuse me. No, I get it, the maximum minimum. You answered my question. Yeah, okay.
So on our agenda, the next item of discussion is the wingspan restrictions. So, John, why don't you give us your perspective on that?
So I'd like to start today in this particular subject and say, oh, this is just very simple and straightforward, but it's absolutely not. And we proved that to ourselves once again. Jim and I had several conversations in regards to this subject, and by the end of it, I was so perplexed by the situation that I actually passed it up to our regional office, who I then had them so confused, they passed it on to our headquarters office. So by the end of it, we all had a lot of conversation in regards to this 95-foot and what does that constitute, and specifically some of the winglet issues that were associated with it. And when we thought we had a very clear...
Sorry, John. I set an alarm clock on my computer and it went off.
Okay, thank you very much.
He wanted to make sure he woke up.
So at the end of the day, even after our conversation, and I got back with Jim when we read the article in the paper, I don't mind telling you and sharing with the group that we actually were getting calls from other divisions of FAA going, wait a minute, this has broad-reaching implications, and their interpretation of the article that was written was different than what we thought it was saying. So there was a lot of confusion around this particular subject. So just for clarity's sake, this was not an easy one for us to just answer in a straightforward manner. But at the end of the day, what it is if you view an aircraft from above, so if you project a light above an aircraft with winglets, that shadow that it's producing directly onto the ground, straight down from those winglet tips, you measure the total outward width. So where the confusion came in is a lot of people said, well, does that mean you measure from the tip of the winglet down to the wing and across the wing and up the winglet, and that gives you wingspan? No, it's from the furthest out points. So if you had something with winglets that was, say, 110 feet at the winglet tip projected down onto the ground, that would be what we would consider its wingspan. To further add to the confusion, when we look at these types of standards, what we're really trying to do is prevent two aircraft from coming together unplanned. It's never a good thing. So the winglets presented a new challenge to somewhat of the aviation community in talking about, well, what's that look like when you've got an airplane operating on a runway without winglets and an airplane operating on a taxiway with winglets. The wingtips aren't necessarily going to come together because a winglet is up and a normal wing is out. So do we have any latitude there? We've had a lot of conversation internally, and quite honestly, FAA, we always err on the side of safety, and we've said we're not even going to consider that a factor. What we're still saying is the wingspan is from tip to tip, projected, horizontal projection on the ground, tip to tip. So in regards to the wingspan restriction here at Aspen, and the reason we were a partner in that when it was developed is truly very straightforward to us, and that is runway taxiway separation. This is already a very complicated airport to operate in and out of because of some of the geographic constraints around the facility, and to fold into that we've got 320-foot runway taxiway separation, which is absolutely the maximum we could have ever hoped for and squeeze any type of operations on the east side. And we were darn happy to get 320 at the time we got it. But that's why we partnered with Aspen at that point to push that through. And a lot of people will say, well, wait a minute, didn't you talk earlier about access and access to an airport, and you don't want to limit that? That's how serious an issue this was to us on a safety perspective, and why we supported it was we were concerned with aircraft operating with a wingspan greater than 95 feet. And there's a complicated formula. We had engineers doing reports and preparing studies to validate that 95-foot. And really what it was, for those of you who weren't here at the time, was the county requested that modification to FAA's design standard with our support, and we signed off and approved that restriction at the airfield. And it was solely based on runway taxiway separation and the safety of operations of aircraft at Aspen. So I don't know if you want me to talk further on it, but I will talk myself in a circle because we got so confused at certain points in our conversation on it.
But there was, the conversation may have been confusing, but the conclusions are clear.
Conclusions are clear.
Okay. Questions? Yes, Rob?
So I just want to make sure I heard you clear. Because of the taxi runway separation, the FAA, regardless of any decision made here, the FAA, for safety reasons, will not allow any planes in and out of our airport larger than a 95-foot wingspan as you have defined it.
So to answer your question
without
directly,
changing the taxiway and the runway separation.
no. The answer to that question is we support Aspen-Pitkin County's efforts to limit the operations to 95 feet based on safety. That is not ultimately the call of the FAA. The board at the time brought that modification to FAA for approval, and we supported it.
So I'm going to ask one more time in a different way. If we asked you, and I'm not saying that we're going to for the general public out there, if we asked you to support a 98-foot wingspan or whatever this new 650 Gulfstream is, there is a chance that the FAA would support that.
Depending on the rationale used in the safety case, and there's a myriad of things that would have to happen, including agreements with the tower and operations, but yes, we would look at that at that point.
Yes, Rachel.
Also, just to be clear, what was then the determination related to the 650 Gulfstream? That it does not meet the 95, or it does meet the 95?
Specifically, as we see it listed on the specifications for Gulfstream's website, and Jim, if you want to jump in, feel free, but they're what we define, FAA defines as wingspan is greater than 95 feet. 99.6 or 7, 8, somewhere in that neighborhood.
Fine, I just wanted the conclusion of all this to be clear.
Yeah, I think it's a really great question. The bottom line is that by code, we have limited aircraft to less than 95 feet of wingspan. As you've heard John describe, determining what that wingspan took us a little bit of clarification, but we now have that. That airplane has a wingspan greater than that 95 feet, so the airplane is not
Doesn't
under
qualify.
county code operating here. It's also important to note, though, that that airplane has not been certified, nor is it operating anywhere currently as part of individual ownership.
So for clarity, to add some conversation, we have multiple facilities operating within the NIPIAS, the National Plan of Integrated Airport Systems, and in the NAS, the National Airspace System, that don't meet standards for the type of aircraft that are currently using them today. So the airport was built, and it was built and designed for very small aircraft, and all of a sudden today we turn around and we have large aircraft using those facilities. So that is the drive and mission that our office undertakes through many planning studies and a global look, is how do we bring those up to standard to meet the aircraft that are currently utilizing them. This particular circumstance is a little bit different because, as Jim said, this aircraft is not currently operating. So it's not operating at Pitkin County. The other complication, quite frankly, is the space limitation that we have at this airport. I mean, it's extremely space constrained. So as we start to look at what can we possibly do, we've exhausted a lot of our options and spent millions of dollars moving that taxiway as far out as we can. So as you look at that as a board, FAA was partners in that restriction in the 95 feet. And when I say partners, we worked actively with the airport to determine what that distance was at the time, that everybody could feel safe with the operations of aircraft at this facility. So I don't take that lightly. It's one of the few restrictions I've seen FAA support. And we have not had any indication that we were going to roll that back from the county at this point. So we're assuming that it remains in full effect today and will for the foreseeable future.
Absolutely.
Any further questions on wingspan? It's, John, thank you so much. The next item on our agenda is for public comment regarding the master planning process. So I'll open it up to public comment. If people will raise their hand and identify themselves and make a short comment, that would be great. Yes, sir.
John Young,
Do we need to hand around a microphone for grassroots? Sorry, we're in a different room than usual for that, but otherwise you're not on the tape.
John Young, just as a footnote, I wrote the grants in 1976 and 77 to acquire the land that we're now arguing over, so kind of an interesting thing to me. My question has to do with security. A second FBO on the opposite side of the airport would seem to open up a whole new exposure to us in terms of, how do we control that, and does that expand our, our service needs or anything, and has that been addressed in the master plan?
Do you want to answer that, Jim?
Sure. The master plan doesn't go into that level of analysis. That would be an effort that would take place with the Transportation Security Administration at the time, and we've already got perimeter fence there. It would perhaps involve some additional gate technology is a possibility, I suppose, but we haven't tried to go to that depth of analysis today.
Further comments? Yes, sir.
Steve Child. It's my understanding that in some other airports across the country where they have similar amount of general aviation traffic, that where there were previously 2 FBOs operating and one of them would pull out because there wasn't really enough business for two FBOs. Given that the amount of general aviation traffic is relatively flat, I'm wondering if we do get a second FBO, what happens if they go out of business? What happens to the facilities?
Good question. Obviously, general aviation's been under a lot of stress these last 10 years, especially the last 5 or so. Unfortunately, there have been some FBOs that have gone gone out of business along the way or consolidated their operations at another larger facility, whatever that may be. I think that in our case, they would probably lose any bonding if that were part of an RFP or request for proposal process. And I suspect there'd be some ownership transition clauses in there as well to bring them back into the county.
Any further comments?
Cliff Runge. Is the county growth management program sufficient from the FAA standpoint to control demand for large, this 100, 200,000 square feet of hangar?
John, are you familiar with that piece?
Yeah, I mean, the question was, I think, is the county growth management sufficient to control the size of the FBO? Is that right, Cliff? So I think that's really a question for Jim.
Well, I tried to give that one to John. The county growth management program is really an interpretation of the county attorney's office, and so I think it'd be better to have, I'll defer that question to the county attorney.
Okay. So Cliff, well, since the county attorney is not present, we'll try to get you an answer, and Jim will respond to you via email. Is that okay?
Will do.
Are there any further questions? Yes, ma'am.
Hi, Jackie.
Jackie Francis, and my question is about the 95-foot wingspan. You alluded to the fact that it wasn't an FAA rule. It's a county rule. So I'd like to ask, what would that take to change it, and how can we be certain that the county commissioners in the future won't change that rule?
Well, I think that's a good question. Thank you, Jackie. The original ruling, if you go back, was done from quite a few studies that focused on that safety component, of which the FAA sponsored and helped the county with. So in partnership with the FAA, both the FAA and Pitkin County felt that was the right number. It's locked in by ordinance. It would have to be changed by ordinance. It'd have to be approved by the FAA for an operating change that also appears unlikely. So I think there's quite a bit in the bank relative to protecting community in that case.
So one more thing to add to the mix of the conversation on that is FAA standards are not getting looser on runway taxiway separation. In fact, they're increasing. And as recently as several years ago, they enacted what we call the elevation rule. So every 100 feet you go above sea level, they want another foot to meet runway taxiway separation. So instead of what our standard used to be at Aspen would be 400 feet, we would add another, 60, what's your elevation?
68.
So we would add another 68 feet to that. So the standard runway taxiway separation at Aspen at that point would be 468 feet, which puts you somewhere in the middle of the terminal, I think, or dang near close. So, I mean, it doesn't leave us a lot of room. It puts us in the apron, but so just understand that those restrictions, because of the types of aircraft that are out there and the operating standards that we're seeing, those restrictions are only getting tighter.
Yeah, and I think from the commissioner point of view, there's never been any discussion whatsoever about lessening the standards at the airport in terms of wingspan. None. The question came up simply because of the theoretical Gulf 650, and it is theoretical. So, any further questions? Yes, sir.
My name's Tim Bannon. We're just wondering on the current master plan, if there's anything that restricts a second FBO under the current scenario that we have in place?
Jim, you want to answer that?
Can you rephrase the question?
Well, the current master plan that exists today, is there anything that prohibits a second FBO from developing today under the current plan?
Yeah, the question about a second FBO today is that the last master plan, which was approved in 2004, was one that had both an acknowledgement of the lease that's currently held by Atlantic in that Lot A, Lot B item that we talked about earlier, and then had the west side that was simply reserved for future aeronautical purposes. So there were two options. It didn't try to clarify which direction the county or the second fixed base operator might go at that time, but there were two potentials that were narratively discussed in that master plan. So the answer to your question in total is it didn't preclude.
Any further questions? Well, seeing none, we have closing questions and comments by the board. So board, yes, Jack?
Yeah, that was a reasonable question about the current master plan, but the current situation is such that we have, and correct me if I'm wrong, collectively decided not to accept applications until the master planning process is done. Is that correct?
Correct.
Okay.
Is that your closing comment, Jack?
No, it won't be until you close it, but
No,
others have an opportunity.
I'm just suggesting that you're on a roll.
Well, I'll ask the second question. I didn't want to jump ahead, but Jim, on page 2 of our memo, talk about key discussion items, overview of master planning process, status of preferred alternatives, under A, modifications, hangar development, parking structure. So my question to John would be, does the FAA have any play, any say, whatever term you want to use, in the development of parking structures on airport property?
Only in regards to height. We would have some comments.
Safety.
Yeah, absolutely. If we're talking airspace concerns, that's where the FAA would weigh in. But we really look at that as a local planning issue, and we don't know the local planning issues as well as you all do.
I suspect, John, you'd also have some interest if you thought there was a safety or security issue related to its location.
Sure, on the say, yeah, if it was, located in the middle of the ramp, we'd have some comments in regards to what we thought about that. But from the security standpoint, we would lean on the Transportation Security Administration to go through that on the security end of things.
Board, any further questions, comments? Yes, Rachel?
I guess the question to begin with, but Jim, you've been doing a series of airport tours for the general public. Are there more of those available, or how do people get a hold of you if they'd like to participate in a tour of the airport?
Well, we'd really appreciate a chance to take folks around. It does take about an hour and a half or thereabouts, so when folks may book their time, they kind of thought that out. Tomorrow afternoon at 2 o'clock, we have a tour. I think we still have a little capacity in that one. We're publishing that tour schedule in the newspaper, so folks can sign up. Or if individuals would like to call me directly, they're welcome to do that. My phone number is 429-2851, 429-2851. I think most of the individuals that have come on that tour have found it helpful, and at least they can visualize and take a one-dimensional drawing and put some kind of life to it, and their feedback has been very helpful.
Thank you, Richard. Any further comments?
Well, just to kind of follow up, sorry about that, this meeting room. And this may be redundant, but I want to be clear. I've tried to discuss this issue a little bit in layperson's terms, and I'm sure I've kind of maybe missed the mark a little bit, but my sense has been that should we be able to move enough buildings to eliminate any sort of taxiway interference and take care of the hotspot concerns on the east side, and were to approve and build a second FBO and kind of use every last inch we can on the east side, that would not still preclude someone from coming in and applying for a new FBO, a third FBO, on the west side And if we had space available and it meets the minimum standards, it is something we would have to entertain in some way, or at least put out a broader request for proposals as well at that time. So if projecting forward 10 years, we've built out the east side to every last inch, and that's being well used. Someone else could still come in and apply to use the west side, and we would have to weigh that, whether it's defined well in our master plan or not. Is that
Correct.
That is correct. Thank you. So appreciate that.
George?
Yeah, thanks. This has been a great conversation. Thank you for attending. I think we've really got a better feeling, I hope, for the purpose and the process of the master plan. We've tried to address some of what I think have been some of the public questions that I received in the community in regards to size, funding, reasons why we may consider expanding our current terminal. And the one question that I haven't asked, that we haven't heard addressed, which I have seen written in the papers and comments, and just to try to get out correct information versus incorrect information, has been on environmental concerns. Because when we talk about increasing the size of the terminal, increasing parking, adding additional FBO, given the community values that we have here in terms of doing all we can to reduce our carbon footprint, I wonder, Jim, if you can address not only what the current philosophy is of the airport, but also some of the awards that you received in terms of following some of those philosophies and the values that this community holds so dear to themselves.
Thank you, George. We, over the years, when we started the master plan back in 2001, the Board of County Commissioners made a couple of things very clear that they wanted from that master plan. They wanted the airport to be safe, and they wanted it to be efficient. Along the way, the environmental component, really has taken a very frontline position at the airport, and we've taken that very seriously to the point where our mission statement at the airport, which is on the back of our business cards, all talk about both safety, efficiency, and environmental sustainability. We were one of the first airports in the nation, certainly one of the first small airports in the nation, to do a greenhouse gas inventory so that we could start to measure and understand where those emissions are coming from, those areas that we had influence over, and what we could do to make a difference. We have a sustainable construction management document that we use with all our construction projects about how to go about minimizing the impacts as part of our construction work that we've been doing over the years, and all those grant dollars that we've been fortunate to put to work to improve safety and efficiency. And that we have an expectation based on the fact we live in a community who has strong sensitivities on the environment, that we take that seriously as well. And that goes down to every single decision that we try to make along the way. One of the cool things on the tour that, if folks will come out and participate, is that one of the things we're doing in some life safety upgrades at the terminal this summer is to replace the water fountain that's inside security with one that makes it more easy to refill large reusable bottles with filtered water and minimize that kind of impact. So there's little things, there's big things. We've reduced our greenhouse gas emissions that are controlled by the county about 9% since we started that initiative. A lot of the greenhouse gases that are emitted as part of airport and aviation activity come from the airplanes, and we have a hard time making much dent in some of those. The good news is the airplanes are getting better all the time as well. The FAA recognized us a year and a half ago or thereabouts for our sustainability work at the airport, and we were very proud to receive that award. We've also been recipients of other acknowledgments by other entities that that reflect the fact that we're trying to make a difference. We're sensitive to talk about it because I think there's such a hesitation to look like you're making a huge difference by acknowledging these awards. But I have learned a couple things along the way, is that, you really do start a journey of 1,000 miles by individual steps, and that's what we're trying to do at the airport, is we're trying to be aware of our footprint, we're trying to be aware about what we can do to improve things. I think the history of this community goes all the way back to the building of the original terminal building in 1975, of which was really a model for all small terminals at the time. They used some very clever technology to try to soften the environmental impact of that facility. Today, that building is very much outdated from an environmental standpoint and needs some fairly significant upgrades to feel close to being current. And I think the code that currently exists in Pickens County for construction is really a LEED's platinum level code standard. So we'd expect to do platinum plus in any improvements that we do at the airport, in buildings or those kind of things. We had a fascinating tour a few weeks ago at the National Renewable Energy Lab in Golden, Colorado. They built the first 200,000 square feet, it's a little over 200,000 square feet, energy neutral building over a 12-month window. And some of the things that they put in place in that process, I think, gives us something to really seriously consider. Should we, consider any other changes at the airport along the way? But we're working hard. Are we proud of ourselves? No. Are we trying to get there? Yes.
Great, thank you.
Well, just throw out a couple of closing comments. Thank you very much for your time here, John and Jim, and all the work that you've put into this process. And we're not done yet, so we've got a lot more work to do. The first thing that I just wanted to just kind of publicly address is one of the concerns that I've heard out there, and actually just heard reiterated during the break, is that the public goes through watching a master plan process, and we go through participating in a master plan process, and the public is participating as well. And there's a general concern out there that the ship is going to be sailing at the end of this master plan process, that we're already going to have made all the decisions that we need to make once the master plan process is done. And I understand that concern. I address that concern with various things like the AACP, thinking, here's a master plan, are we writing the tickets now, or are we going to really analyze things further down the road, and is it going to have the public input when we get to those things? And these things are things like the building size, the FBO, those sorts of things. In addressing that concern, and I hope I speak for the rest of the commissioners, but I'll speak for myself, we're going to do everything we possibly can to make those as public as possible and to analyze everything as much as possible, if not more than we are in this master plan process when we determine the size of this building, the actual location of things, and all of that. And we just haven't gotten there yet. So I want that to be put out there to the public. The other concern that's been raised a couple of times out there is that who's the policymaker on these things? The 5 people that are sitting on this end of the table here, excluding John, who's an employee directly of these 5 people, we are the policymakers. We're the ones that have been elected by the general public. It's not the airport director. The airport director has done a tremendous job giving us lots of different information from lots of different directions. We're the ones that are the policymaker. We're not getting railroaded on this by any means, and we're analyzing a lot of things, and we're going to continue analyzing a lot of things. We're still asking for more data on parking information that we're going to have as this process continues, the size of the terminal as this process continues, FBOs, safety regulations, all sorts of things. But ultimately, it's this board that's the policymaker, and the airport is not a ship sailing itself. So I want to make sure that people out there don't think that's happening either. I think Jim and his staff have done a tremendous job. John Peacock has done a tremendous job bringing information to us
independently, without bias, so that we can make determinations as policymakers.
Well said.
I'll just end where I began, which is to reiterate what we've done so far in terms of a public process. We've had 11 charrettes. We've had 5 citizen input committee meetings. We've had 2 open houses. We've had 9 small group meetings. We've had 14 airport tours. And we've had 8 BOCC work sessions. This is the 9th work session. So that's 50 meetings so far on this subject, and we expect more. So, just let me finish, Jack. I want to thank John Bauer and Mark for coming up. The resource that you represent is a tremendous asset to, certainly to Pickens County, but certainly to the nation also. And we deeply appreciate your time coming up to ask me. And I speak for the board on that. Jack?
Yeah, thank you, Michael. Within the recent past few months, we've had a number of community concerns expressed through various modes, interpersonal, newspaper, etc. And though not right on, in my opinion, factually, they certainly express a true, heartfelt concern in this community about what might happen at the airport. And obviously, Rob is right on in all the things that we're going to do and are doing to make sure that we attempt to link with the public and the law, the FAA, all of that. And I certainly support the idea of the concerns, but people must understand, the general public must understand, that if they have concerns, get involved. Like, for example, these airport tours, I've heard a number of comments by some naysayers that they've been helpful on the education level. So that's all good. But for me, a major issue, whether it's other than the legal requirements, the issue of the terminal and the need and the demand and what's going to spark us investing X amount of dollars in this new facility, because I believe it is a new facility we're talking about, still hasn't been answered. I know there's studies and et cetera, but what I understand, the employments equal X today, for example, commercial airport I'm talking about, the commercial side, and our future growth. And growth is very hard to predict. You can add a percentage per year and do a multiplier, but that doesn't give us the reality on the ground, as it were. So those decisions we're going to make, and collectively, hopefully, with the public. But I certainly have a lot of empathy for those who are very concerned about what might be. And to me, I speak again right here for myself, one of our biggest issues are those grant assurances. Because those grant assurances assure me that we might get something at the airport that we don't want, quite frankly. I'm okay with a second FBO. It's just how it all plays and how, really where it is and what it means. Having heard from you, John, that we really can't use some of the tools we use in local land use, like conservation easements. I appreciate the heads up, and at some juncture, it would be great to have a list of those 39 grant assurances, because we've heard it bits and pieces over time, but the document would be helpful. But where we're headed, I think, is a continued bright future at the airport. Jim's staff consultants do a great job. They came in with a rather large program, and we've scaled it back. That's a fact. But my question to you, John, is does the FAA get involved in the need, the demand piece? On either side, I don't mean the legal issue of FBOs, but...
So, let's turn it to terminals.
Yeah, the terminal, for example.
When we look at need, is reflected in how we apply funding under the Airport Improvement Program. So that's how you will gauge our partnership in the need aspect. So if we believe there is a high need for something at Aspen, whether it be terminal, runway extension, we participate with federal grant aid dollars to show that. So that's how we get involved in need. It's also done through the forecast. I mean, it is a tough thing to predict, and we could probably go back and look, and some we hit right on, some were way off one way, some were way out, you know, there's a lot of variables that go into that. So from the forecasting, we do look at need because we do approve the forecast, but really where it plays out economically is our participation in how we fund things.
Thank you.
Okay, thank you. We've reached our time limit, just barely here, so thank you again, and we appreciate you being here. Okay, we're going to take a break.
John?
I really look at the struggle that you all are in, all the external pressures from us, from the public, the media, it's a very complex situation.
Welcome back. It's 3:45 on May 22nd, 2012. This is the Board of County Commissioners work session. The next item of business is the MOIs. And first on the MOIs is the Road Capital Improvement Plan. I see Brian Pettit at the very back row of the room, which is quite a distance in this room. Brian, are you going to present this? And Connie, are you going to back up what Brian said?
I hope so. Well, I don't know if there's a lot of presentation needed, but the idea of this has been discussed with the board before, which was to try to piggyback off of volume discounts that CDOT received based on their Highway 82 paving project this year. The local contractor, Elam Construction, decided to honor their costs with a small premium to do some of the outlying roads like Castle Creek Road, Emma, Sopris, and Willoughby Way. And so we're bringing the supplemental request to the board today to complete those roads that I've just listed, along with Smith Hill Road and Jack Redding Lane. We also placed a contingency item in there to the tune of about $250,000. When you're doing this magnitude of work, you never know what you're going to run into, and if we run into something unexpected, then we would want to fix it then and not have to come back to the board to ask for money. If everything goes smoothly and the pavement goes down without a hitch, we will not tap this money unless we need to. This would be for any unforeseen circumstances. What Connie passed out is a spreadsheet to show the overall impact of this plan to our 10-year capital plan. As you know, if we do the roads this year, then they come off that capital plan, and but however, there is some impact in the out years, and Connie will go over that.
If you see on this spreadsheet, the blue highlighted cells show where the changes have occurred in this plan. Smith Hill and Jack Gradick are just lower costs. They were already planned to be done in 2012. We just have a cost reduction because of this favorable bid. Then the other projects, Castle Creek was originally in 2014. It's been moved up, but the scope has also been changed, and so on down the list. So what we get at the bottom is, in the blue highlighted row, the new plan. This shows the new dollar amounts for all of the road projects. The next line down, original plan, this is what you approved in the 2012 budget process. And then the very bottom line shows the difference between the two. What's the dollar change between what you approved in the budget plan and this proposal? So you'll see that in the first year, in 2012, it's almost $3 million more than what was approved in the budget. But then going through the out years, 2014 through 2018, there are savings because some of these projects come off of the plan. They'll be done in 2012. Overall, the total net cost of making this change is $337,000. And that's over an 11-year period. So it's a fairly small increase in the overall cost, considering the scope of the work that's going to be done, especially with Castle Creek Road, which is a significant change to what was originally in the 10-year plan. Questions?
Thank you both for this. I think I have two questions. One is that are the dollar amounts, knowing their estimates, in the out years, are they inflated over time? Is there an inflation factor for the estimated cost?
Yes,
okay.
there is. Mm-hmm.
Thank you. And then the second is, I am very supportive of pulling this forward with the more favorable bid and getting the work done sooner to maintain our roads, but I'm wondering why we haven't put anything in for 2013.
Rachel, if you look up above, the 2013, we have pavement maintenance and then road capital, so most of our 2013 appropriations are improvements in the AABC on the Frying Pan Road and
So there are actual improvements, less maintenance?
That's correct. So we actually still have $3.2 million in road projects budgeted for 2013 in this plan.
Okay. Thank you very much for the clarification.
Yes, Bob, George?
Just real quickly to clarify what, a little of what Rachel said. You said the inflationary cost is budgeted into this, but when we say that the difference between the new plan and the old plan is $337,000, that's not taking the time value of money of what that is today, is it? So it's actually, the cost is much less because we're getting the benefit now versus
Yes.
in the future. So
Yeah, this is the most conservative, I mean, this is on a, we wanted to show you the difference in the plan over the 10-year period because we only have so many dollars dedicated to the plan, so you could see that. But Rob, you're absolutely right. If we were to do a net present value calculation, this would look a lot more favorable.
it would probably be somewhere in the half of that because it's after over 11-year time span, or an
Right.
average of 6 years, take it half of it.
And then
So it's whatever the interest rate is on that money over that time period.
Right. And then, as Brian said, there's also the $250,000 added in for additional contingency, which may not be used. If you take that out, really the cost difference is minimal.
And I also just want to note also, there's cost savings, but it's also a substantial quality improvement for these roads as well. With the work we're doing, especially on Castle Creek Road, the full depth overlay, the whole length is a much better road in the end than just a chip seal halfway up.
Very good.
Jack? Oh, I'm sorry, George, and then Jack.
Brian, a couple of questions on the, these are all overlay projects. So in terms of the process, does the existing pavement get tilled up and then overlaid?
In most cases not. There may be some areas where we need to do some leveling and some milling, especially the top of Castle Creek Road. That road is pretty well, there's not much of a road there, I guess. And so we'd want to just get back to a road-based surface, compact it, and then add an overlay on top of that. But with regard to like Emma and Soapers Creek, there's good asphalt there that we can build off of. So in a nutshell, what I'm telling you is in some cases that we may do some milling. In most cases, I don't think it's going to be necessary.
And then, I think you answered my second question, but in terms of areas where you'll need road base, that's tentatively in this budget, or that's sort of the contingency dollars?
If we need additional road base, it'd need to come out of contingency. In the case of Upper Castle Creek Road, where we need to do some milling, we're hoping there's enough substance there to build asphalt onto, but if we need to add some more road base to build structure, then we'll do that.
Yeah, I mean, the problem on Soapers Creek, right by the curve where there's a culvert that goes underneath, which is an ongoing problem in terms of pavement not holding. So that whole area is going to have to probably be redone and whole new road base or however to try to address that drainage issue. You know what I mean?
Yeah, I do know where you mean,
Yeah.
on Soapers Creek Road.
Right.
Yeah.
And then, as long as you're here, it's not on this budget, but under the normal budget for the coming year, under road and maintenance, West Soapers Creek, which I mentioned to you last fall, that project that was done a year or so ago has really deteriorated. I mean, that job just didn't work, and I don't know whose fault it was, but it's terrible, basically. I know if you've been up there recently, you know what I'm talking about. Will that fall under this year's normal maintenance and upkeep to try to fix that?
Yeah, there's no capital dollars that's been budgeted for West Soapers Creek. However, from a maintenance standpoint, we would handle that internally with Road and Bridge Department for any kind of asphalt work that needs to be done. If it's beyond their scope, if it's something more substantial, we would certainly, we have a contractor online now to do this kind of work that we work through to correct it. If there's a safety issue or if the roads fail to that degree.
Well, I think it's both.
Okay.
If you haven't been up there, take a ride up there and see for yourself.
Okay.
Yeah. All right, thanks.
Brian, do you have an explanation of why during your presentation there's only one person in the room, given last? I'm just kidding, Brian. This is very exciting.
Roads are not sexy. I never said they were, yeah.
I think the public, though, is going to be deeply appreciative of this plan and the improvement to Castle Creek Road. It's a highly used road, certainly by recreational bicyclists who appreciate a good, smooth surface. So thank you for being innovative on both the jumping the project ahead and the cost of the project. I appreciate it.
Thank you.
Any further questions? Yes, Jack?
Yeah, when I look at this budget, it looks like in an attempt to do an apples to apples, we come out with an additional $337,000. But the reality is we save a huge amount of money by advancing the projects, but the additional cost really boils down to the $1.6 million extra for Castle Creek Road. So, and I don't know what other fruit apples to apples, well, this might be apples to oranges, but the reality is there's real true cost savings here, and I can't sift through it to figure that out, what it really is. If we would have included the 2.6, it is 2.6, and then minus 1.6 for the additional. But, these numbers are great. I fully support this. I'm appreciative of the initiative of staff working with CDOT or realizing that opportunity was here. And we all will benefit greatly over time for this project this year. And when we had our retreat, we all were receptive to Rob's idea of maybe advancing some dollars to get bang for the buck, and here it is. So right on to everybody.
Yes, Rob.
Well, I'd add on to that I think some of the cost savings are in the out 12th, 13th, 14th, 15th year because of the additional overlay that we're doing. Our maintenance program in the years that aren't reflected here isn't reflected here because we haven't budgeted out that far, but instead of having to do a major repair in year 13 or 14, now we've got a full overlay, so those roads will last a longer period of time. And that's another element of savings that's not totally reflected here. I think there's win-win-wins all around, not just the economies of scale and the bid process, but also the foresight to see that those roads are going to have major repairs done down the road, so we might as well do them now. It's the most cost-efficient way to do it.
That's correct.
So very good work, Brian.
Good, thank you.
Yes, Rita.
Yeah, thanks. Brian, I was just going to ask, what is going to be our public outreach plan to make sure the public is aware of when there's closures or delays or anything like that?
Yes, and we're working with Pat Bingham right now to set up a program, and we're looking at not only newspaper ads, but also radio spots to get the information out about this program, as well as CDOT's program. That one actually will probably have more impact to the traveling public than the county roads, but I think if we can work with CDOT and develop a program for our print media and radio, I think we can get the information out to people. And certainly our website will be updated weekly so that we have that information for people as well.
Yeah, it may be something that the Chamber of Commerce would consider doing some blast emails as well, because they have a great email list, and, reaching out to the business community in that sense, I think would be really valuable.
Great.
Just a second, Jack. Brian, what is the CDOT project on 82? Could you give me the scope of that project?
Yeah, I can. It goes from Basalt Avenue, the main entrance to Basalt, down valley to Original Road. And I think the number's around 2.2 miles. And that's an overlay. There's milling that will occur as well. They'll fix guardrail as part of that project and replace some signs. The Up Valley section goes from just this side of Snowmass Canyon, right at Jerobosdale, all the way to the ABC, which is over 7 miles of paving. And there's milling, paving, and guardrail repair. And along with that, in working cooperative with CDOT, we asked them to create a double left-hand turn lane coming out of the Airport Business Center, coming up Valley to Aspen. And I believe that that's part of this project as well, so that we'll reconfigure that intersection a little bit to allow traffic to flow out of the ABC a little bit more quickly with a double left-hand turn lane. So it's an extensive paving project. As part of that, all the bus stops will be redone as well because the elevation of the road will change. And so that will impact the public pretty tremendously, but CDOT's aware of that, and they're trying to stay away from the commuting times so that people get to work on time.
Jack?
Yeah, Rachel's right on about asking the question, something several of us have asked before about the outreach specific to Sumas Village. But definitely work with, I don't know if it's marketing, you could work with Russ, the manager, specifically to get the word out to the business community. And people are going to have to understand, though there's some inconvenience here, this is a huge plus. So be patient, work with us, and we're going to get all of this done this year. If I might, Michael, another question off topic about Coal Creek. Have we put out that for bid?
We have. We received bids, and we received many. And I believe that will be coming to a contract very soon. We're still working on the easements with local landowners, but there'll be a savings based on bidding it this year, a tremendous savings. It was a good move to delay that on a few fronts. Not only the savings, we had more competition because there was not a rush, and then also we've happened to have a low snow year where the water is minimal, which will help this project out, even though it's not necessarily.
There's something positive in that, huh?
That's right. Always a positive.
Yes, George.
Brian, back to 82. So CDOT is going to be milling 82 because that road has failed to such a point that really needs to happen, that process, versus what we're doing with our county roads?
Correct. There's some problems on 82. There's some failures and also some significant wheel rutting. And so in order to make a flat platform to place asphalt and get consistent compaction, you've got to mill those wheel ruts out or you don't get consistent compaction across the platform. So that's primarily why CDOT's doing it.
And then the work that they may be doing at the Airport Business Center, are they also going to be doing some of the utility movement for the underpass this summer as well?
We will be, it's called potholing. We're going to be figuring out exactly where those utilities are so that we can make plans to move them. We may not get them moved this year, but we're going to make the plan based on what is actually in the field. There's an extensive amount of utilities out there, so what you'll be seeing probably early to mid-June is contractors out along that area just drilling down to find out where the different utilities are so that we know how to move them for the underpass.
Hopefully they won't be hitting too many of those utilities as they're trying to locate them.
We hope not.
Yeah, that's always a problem.
Any further questions? Yes.
Mike, I just, building on some of the comments that Jack had made, we are setting up some project coordination meetings with municipalities, and we'll try and work with utility providers. We get all of that, as much coordination as done in what is now a very short project timeline, and also build our public information program off of some of that coordination work that we do too.
Okay, board, are we done? Any more questions? Thank you, Brian. Thank you.
Thank you,
Connie.
everyone,
We
for your work.
appreciate it. The next items are thank you letters, one from the neighborhood clinic at Woody Creek, and then a really delightful one from Tabor. Does it give Tabor's last name?
No, we don't know Tabor's.
I wish we got more letters like this. It's a handwritten note, and just let me read it out loud. It says, the BOCC, thank you for your scholarship so much. AVSC meant so much to me.
My class, Cliff, and I had so much fun, so much excitement. I learned to do moguls and deep tree moguls too. I became friends with Sloan, and I will ski for the fest of my life, which is, I like having the fest of your life. That's great. So thank you, Tabor. We appreciate your letter very, very much. And there's a small picture of Tabor.
And he's also getting there.
Yeah. And then we have a thank you letter also from Lift Up, Michael Powell of Lift Up. So thank you for that letter also. What are we, next, are we on future agendas? Is that what we're on?
Yeah. And just a couple of items to point out to you. We are still working on June 7th for some more travel time. We may need to move that site visit up a little bit in order to achieve that. So we were a little short-handed last week in getting all that put through. So, and then later this week, on May 24th, which is not necessarily on your future agendas, just a reminder, this Thursday we do have the Healthcare Summit. Jack has indicated he would not be able to attend. I think, Rachel, you'll be in attendance. I don't know if any of the other three board members are available or interested in attending that from 9 to 1. It'll be Rachel then.
Okay.
That's all I have on future agendas. Right
Board
now.
future agendas?
I've got a couple. John, on January 19th, where we've got a joint meeting with the Open Space and Trails, we had changed this last time, where we have a lunch break. I would suggest a working lunch again, because we never have enough time.
That's a good catch.
And then on June 27th, I'm still sort of toying with the idea of going back to D.C. and meet with our legislators. I haven't made that decision, but I may not be here for that meeting on the 27th.
Board, any other?
Well, I had mentioned it before, but I will be traveling over to Avon tomorrow for the to-be-determined process, looking at the funding shortfalls in all the areas of the state, and I may be here for the first hour of our meeting, but then have to leave.
Thank you, Rachel. Yes, Jack?
Yeah, unfortunately, Tuesday, June 5th, I won't be here, and though we have Monday through Wednesday for the Colorado Counties Conference, the summer conference, it didn't note, so you might want to note that I won't be here. I have to say unfortunate because I always prefer to be here than away, even if it's on business, but this one's an annual important one.
Any further future agendas? We have open discussion now, John?
Yeah, I've got a few items for you. First, just an update that we have received responses to our RFQ for a real estate broker. Staff is evaluating those right now, and I guess this should have been on future agendas. We had originally indicated that we try and do interviews on May 31st. I think there was no one available from the board during that week, so we're going to be pushing that schedule back, and we'll be getting a notice out to you as we work through that. We still have 2 staff members who are on vacation that need to review the RFQs at this time, but we are moving forward with that. The other thing I have for you is we did receive a request from Colorado Water Workshop. Each year, they are doing I guess it's a forum, a water forum that the board has provided some funding to in the past. They again are requesting that we provide funding. Just wanted to see if there is any interest on the board's part in looking at this and having us maybe look at a proposal from your discretionary fund.
Yes, Jack.
John, do you have any history for us as to what we've participated in?
I don't, I can certainly get that for you. I just saw this actually yesterday, I think.
It's
Do you have it?
usually $300 to $500 for most, $300 usually. And I think they've been sporadic in asking us, so it's been, off and on over the years. I can look at the discretionary fund right now.
We can pull that up here.
Rachel?
Yeah, I have to tell you, I've never been able to attend one of these. It's held at Gunnison. I understand they're very good, but it just never hits with my schedule. And actually, again, this year, I'll just be getting back from NACO and have a QQ meeting with Northwest Council of Governments the 19th over in Eagle. So I know I won't be able to attend. But it does include a complimentary registration at the $500 level. And so I do not know, but to the extent that anyone with our Healthy Rivers and Stream Fund would like to attend, or other board members or our staff, it's a traditional function of Gunnison, the university there, and it seems to be very, very well received. And so, I can see supporting it, and I think particularly if we can get someone who can take advantage of the registration value.
George? Yeah, I did actually have an opportunity to attend a few years back, and it was really a well-run and really informative conference, and I would probably be interested in attending again. I'll have to look at my calendar, but regardless, I think we should support this. We should have our name out there in terms of our endorsing all the work that is happening, certainly on the western slope for water.
The good news on this is it's not a Wednesday, regular meeting date. It's 18, 19, 20. So we don't have any meetings at this time.
Okay.
And if you might not go, George, maybe I would go then.
But it shouldn't limit just to one of us. I mean, because
Yeah.
we have our own budget anyway. I think it's worthwhile to go to, so.
Yeah, well, that might be.
Yeah. And it looks like last time we probably did a sponsorship at the $400 level, and I'm sure those have moved up.
Yeah.
Is the board in agreement with $400?
Or 500 would get us to sponsorship.
500? I see a nod of heads.
Okay.
This is it.
And then the last item, I just wanted to hand out, CCI is again looking for legislative issues for the upcoming session. These aren't due in until June 22nd, and so I wasn't planning on necessarily discussing these today. I more just wanted to get it on your radar screen. We will be also having staff looking at these, and we'll set aside some time in a work session in June to have further discussion. But I just wanted to prompt your thinking about these, and if you have some items, it would be good to maybe get them to me over the next week or so, and we'll start compiling a list that we can bring back to discuss.
Great.
Yes, Rachel?
Yeah, thank you. I have to apologize, I don't have the date right in front of me, but I also know the date is coming up in June for any potential NACO resolutions going forward. I'm in the Public Lands Committee, that's where I would be able to speak to one, but again, given some of the tenor of the larger population of that group, I've been very fearful that if I was to introduce a resolution saying we support current wilderness areas, and kind of countervening that Sportsman Heritage Act, which wants to start logging and building roads in them, that it would be amended at the floor to say, well, we support wilderness areas, but no more, and get rid of all the wilderness study areas or something like that. I mean, it's just, Lynn Padgett did come up with a very good one on Good Samaritan legislation on mining activities, and we're hoping to continue to see that one go forward. But, there's a pro and con to what you introduce in that group. So if anyone can think of one or we want to talk about it, feel free to give me a call and talk about it again.
Yeah, I'm sorry, I do have one more item. We're just looking at our notes here. We do have some citizen board. Well, do we have a new person coming in here?
No, for the housing board, there's two openings. And the current members, both Kristen Sable and Kristen Sable and Marcia Goshorn applied for those two positions, but also another person applied for one of those two positions, and his name is Steve Stenda, and you've interviewed them.
Yeah, and so we're seeking if you wanted to give any direction at this time, or if you guys need background.
I would at least have to pull my notes.
Okay.
To just recollect.
We'll bring that back. We'll put a memo together and bring that back to you guys.
Are you asking whether we would or would not interview the third individual?
You already did interview. It's bringing back the appointments, but I think at this point, right now, maybe what we need to do is do a memo for you, reminding you of what seats you still have to appoint and who we've interviewed. So we'll do that for the next time we're together.
Okay, Rachel?
Yeah, and this actually kind of brings up an issue to me while we're working through this kind of realignment of our board appointments and boards. And I think it's valuable that we are personally interviewing re-applications for the Open Space and Trails and P&Z. But when we're not re-interviewing individuals who have already served, and then they're kind of in competition with new individuals who've been fresh and in front of us, it may set up a little bit of a disadvantage to the person who's been serving for 4 years, going for meetings, dealing with tough issues, but we don't see their work or hear their work. Now, we have the little form that, says, but, I'm just kind of wondering, and I don't have a firm direction on it, but it seems that if there really was a quote, competition, you'd want to have interviewed face-to-face the person who you're politely refusing, to renew. And not that that's specific to these people at all or anything like that, but it really did strike me that here we're interviewing one person who may replace a seated member who's looking to be reappointed, and have they even had that chance to talk with us about their service? So I don't know if that means...
So what's your suggestion?
Well, I don't know if we need to continue to modify our evolving policy to say that, if there's competition for renewal seats, that we will interview the person who's reapplying as well, even if it's not, P&Z or Open Space and Trails.
George?
I agree with that. I think I mentioned that a while back, that because we were interviewing some new applicants, but there were some existing current board members who were just reapplying, and I mentioned, well, should we re-interview these people? And I don't know the board really had a good discussion on that, but for me to sort of, again, some of these people I may not know anyway. I may not have appointed because I wasn't on the board then, but I've interviewed a new applicant, but I have no sort of comparison with the current holder of that seat.
Rest of the board? Jay?
I think it's an issue, in the sense that it's an intellectual question, but for me, I guess where I'd go is I would interview the new person and then decide whether I wanted to interview the others. And I'm looking maybe because I know Marcia and Christian Sable. That's, I forget her first name. She works for the city. And I don't know, I tend to not agree with trying to interview everybody. So modification is what you're talking about. I really don't know where I'm at.
So what about the solution of if the commissioners feel they need to do it, we retain the flexibility to do it. If one commissioner wants to interview members because, for whatever reason, they can ask that happen.
If this is a little open dialogue, I guess I would feel a little uncomfortable about that because I'd like to see a little bit of equal application of whatever policy we have come forward. And I also would feel a little awkward because we don't know till we really finally get to that point of discussing the applicants of whether people are feeling, oh, no, don't want them on board again, or, oh, yes, definitely want them on a board because I know them. And it's only at that time that you hear it that you have to say, wait, I want to interview him, you know, so it might be a lot of catch-up and maybe meaningless at that point if others have already said, no, I've heard things on the street, I've heard this, I didn't like that decision, so no way they're going to get my vote, you know, and so I just think we should come up with something that's evenly applied and equal opportunity, so that someone says, well, they didn't even give me the benefit of a face-to-face, and it's always awkward whenever you choose not to reappoint someone who has served before for any number of reasons, but I would feel they deserve that benefit of face-to-face to tell you why they want to reapply. And, you know, I guess my solution would be to do the interviews kind of automatically when there's, quote, again, competition for a seat.
So, George, you're in favor of that?
Yeah, because I just want to reinforce Rachel's comments. I think to have sort of a neutral format, unbiased format, because I think it'd be very awkward if we interview a new applicant and only one of the existing applicants, board members, and then that other existing board member we decide not to reappoint and they didn't have a chance to interview. I think that would be a travesty. So, and frankly, I was actually opposed to the generic interviewing of the open space and P&Z just in general. So I think we should interview new applicants and applicants who are reapplying.
Rob, how do you feel about it?
That's the way I feel.
Okay, so that's the way the board's going to go.
Can I just be sure I understand what we just said? So that's not necessarily for all boards. That's just in the case where we have new applicants and re-applicants, where we have more applicants than the number of seats. Did I hear that correctly?
That's what my understanding was.
Okay.
I
just want to make sure we weren't now interviewing all re-applicants, which is what I thought I heard. So, okay, thank you.
Okay, thank you.
Any other open discussion items?
Not for me.
Jack?
So I have a question of how we're going to handle the potential, whenever it comes, of interviewing the realtors, because three of us have indicated that we might be interested. And we certainly probably don't want three of us, because then it's a meeting.
Rock, scissors, paper?
Pardon?
Yeah, I thought there was an agreement on an arm wrestling match or something at the last meeting. But I do think it would be nice to have some direction so we could coordinate schedules with whichever board members are going to be participating in that process.
Yeah, so I'm forcing the issue and asking the question.
Yeah. Well, I'm happy to defer. I'm not getting in the middle of that one. You know, I
thought it was George and Rob, because you had already generously.
Thank you.
Deferring again.
Generous again.
So we'll leave it that George and Rob will be participating in the interview, or do you want?
I think Jack was in there too.
Yeah,
three.
I was the first one to say, well, I wouldn't mind. We all have appropriate backgrounds in one way or another, so.
So will we have to notice those meetings?
Well, and then
Or is it
they
a
would be
personnel
public
meeting?
meetings. Yeah.
Yeah, what?
Yes, you would have a quorum of the board, and so it'd have to be noticed, and it'd be a public meeting at that point.
Would be a public meeting. So that makes an interview a little awkward.
Yeah.
Yes,
Yeah.
Rachel?
Well, you know, I guess what I'm kind of wondering, and I don't want to make it unduly tough, but when we interviewed for manager's position, we had kind of a round robin of the manager applicants talking to our board, talking to staff, and so on, and maybe you just set up two teams, and they interview with two different sets, and one set can be two commissioners and some people, and then they go to a third set with some staff and the third commissioner, and it doesn't, you know, so that it's not at the same time or in the same room or hearing the same questions, but, you know, there can be some comparison of notes afterwards about, as a personnel matter or as a negotiation, of their impressions of the applicants. And so maybe we can set up a process that prevents it from being a quorum, but still allows as many commissioners as possible to have at least a chance to ask their questions of those applicants.
Yeah, I'm just trying to think, I mean, that's an innovative solution. I'm trying to think of whether that meets the I don't know that we can break up the meetings that way for the purpose of not having a
quorum.
Yeah.
Well,
To avoid the sunshine.
My understanding, part of the quorum and sunshine, would be something at least to investigate with John Ely, is that it's about not taking direction or making decisions about public policy and discussing public policy. And no one interviewing is going to be setting public policy or things like that. And so, I mean, it may be a recommendation to the board, but I would just investigate with John Ely and see if there's a potential.
Are there any other solutions for dealing with this? Does one commissioner feel like withdrawing? Yes, George.
I don't see a problem having three commissioners and having notice, and it's just like we're interviewing board members. It's going to be, I don't know that it would generate any public interest, but I'm not sure why that would be a problem anyway. We're just going to be asking some questions like we normally do, getting some responses, and then and go from there.
That's another.
I don't see an issue.
Yeah, and I think sometimes you can achieve more candid responses, especially if it concerns business practices and such, when you're not necessarily in the public forum, and that makes the interview more useful. It's part of the reason that personnel interviews tend to not be subject to those same type of public view. It just changes the nature of the discussion and the information that may be brought forward, especially from a party that may be sharing private business practices. And, is there anything proprietary in here? Maybe, maybe not, but we may not get as thorough an examination of the candidates would be my only concern.
And then I guess my last comment would be then, depending on the schedule, may knock one of us out, and if not, we should maybe just draw straws.
I'll stay on May 31st then.
Right.
Yeah, I think one of the hang-ups about the problems with three is then notes are required also, minutes, whatever, and I was going to suggest straws. I mean, let's just do it. I mean, three able individuals, probably doesn't matter who shows, but everyone gets the same chance, as long as someone makes the straws distinctively different in size.
Do we have straws present at this meeting?
I have paper clips I could pull apart real quick, but maybe the three of us could get together and we'll just do some kind of lottery.
You can do that at the end of tomorrow.
But it may, depending on when your schedule is, when you're going to schedule, it may exempt one of us anyway.
Well, and in part, I was going to partly drive that schedule based on who was participating. So maybe let's see who can participate, and then we'll work on the schedule.
Okay, thank you. Any further open discussion?
Are we going to have some discussion on the legislative potential issues? Because this is the beginning of rolling the ball for what happens in September, which will be the first CCI Legislative Committee meeting.
And Jack, my thought in handing this out is the CCI has requested that those be returned June 22nd, and so we had set aside some work session time to discuss them. I just wanted to get your juices flowing.
Yeah.
Unless you want to talk about them now.
I apologize if I missed that. I don't think I did.
Thank you, and I'd like to have a longer discussion later. A couple of things have come to mind for me, but I think particularly we want to talk to the department heads and see if there's issues that we need legislatively brought forward from Health and Human Service or other departments that have been roadblocks they've been running into effective governance. So it shouldn't just have to be generated from our table. It's also what our staffs are finding.
We'll hand this out at section leaders and discuss it tomorrow.
Okay, thank you.
Any further open discussion? Should we adjourn?
It's not 5 o'clock yet.
I know. We should adjourn. Thank you very much.
Thank you, Pressford.
Susan and John.